Good morning, Chair. Can I please call Anthony Rogers?
Yes.
Please stand. Please repeat after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth. Thank you very much. Please stand.
Yes.
Mr. Rogers, you are His Majesty's Chief Inspector of the CPS Inspectorate, is that correct?
That is correct.
You were officially appointed, I think, in February 2025, though you held the role on a temporary basis in 2024, is that right?
That is right.
You previously held roles in the civil service and since 2003 at HMCPSI.
Yes, but I left HMCPSI in 2012, went to become the first head of compliance in the Crown Prosecution Service. I then was area business manager in the Crown Prosecution Service for the London area. I then left the civil service in 2016, took up some consultancy work, and then returned back to HMCPSI in 2018.
Thank you. Could I ask you perhaps to come slightly closer to the microphone if possible? Thank you. You're giving evidence today in respect of the HMCPSI report into the CPS's actions in the prosecution of VC. Your evidence is taken slightly out of order in respect of our overall timetable. I'd just make it clear at the very beginning that the inquiry has obviously been gathering evidence for over a year now, and there's nothing in our terms of reference that would prevent the Chair from reaching conclusions that are different to those set out in your report. And it's for that reason that I'm not going to take you to a particular document and ask if that would have changed your opinion, and I'm not going to ask you to give evidence as some sort of expert on prosecution matters. What I want to ask you today concerns essentially the sufficiency of the inspection and the report. Could I please ask you to turn to HMCP 40625? Thank you. So this is the report, and if we could start please on page 99.
Yep.
This is the beginning of HMCPSI's involvement, and that is a letter from the Attorney General, the then Attorney General, to your predecessor, Andrew Cayley, King's Counsel. Is that right?
That's right.
And the request is that following the sentencing of VC, she would like the Inspectorate to undertake a thorough and rapid inspection of the CPS actions in that case. And the report was due by Easter time, is that right?
That's right, yeah.
How long do your inspections usually take?
A normal inspection would, depending on whether there is a file examination, could take anything up to, from beginning to end, 6 months. 6 months.
So this is considerably quicker than your ordinary inspection?
Yeah, I conducted 2 COVID inspections after the pandemic when I was Deputy Chief Inspector, and I managed to deliver those in 12 weeks from beginning to end.
And here it's envisaged approximately 2 months, so approximately 8 weeks.
Yeah.
So quicker than the COVID ones, considerably quicker than an ordinary inspection. Thorough and rapid are not necessarily good friends with one another when it comes to an inspection. Is that something that you would agree with?
Not in this case, as it's a single case. I think that is possible, and I think we did conduct a thorough and rapid inspection. Obviously, I, in my statement, have some reflections on if we were to ask to do it again, what I would do differently.
Because broadly there is a tension between the two.
There is, especially when you're trying to engage with bereaved families in an inspection of this nature.
And at this particular time, I think Andrew Cayley, King's Counsel, had recently stepped down.
Yeah, Andrew resigned to go back to the International Criminal Court. He'd announced that resignation in January. I was appointed, you can only have one Chief Inspector because of the Act, and I was appointed to take up post on the 27th of February. Andrew was still Chief Inspector, but he wasn't with the Inspectorate. He'd actually gone over to The Hague. So I was running the Inspectorate, but I wasn't officially the Chief Inspector because you can only ever have one.
And he had stepped down after a 3-year term, so not serving the full term.
Yeah.
Am I right in saying that there wasn't at that time a succession plan prior to his...
No, Andrew's term would have been 5 years. Normally it's advertised, sorry, 4 years, I apologies. It's 5 years with me, it was 4 with Andrew. So Andrew would have had, he'd stepped down actually after about 25 months, I think. He'd got into his 3rd year.
Thank you. You've also said in your witness statement that HMCPSI was fully committed in respect of the existing inspections that were taking place at that time. Is that right?
Yes, absolutely.
And you put together a team that included Richard Whittam, King's Counsel, former First Treasury Counsel. Presumably he had other cases on at the same time.
He was on Horizon, but Horizon was stood down at that time, so Richard had time to be with us. So he was counsel on Horizon, representing, I think, Fujitsu.
And I think the inquiry wasn't sitting at that particular time, but was resuming in March, April time.
Yes, that's right.
Jo Milner is a name that will come across.
Yep.
She's a legal inspector, former prosecutor.
Yeah.
I think we've seen on emails, or we will see on emails, that she was working on a temporary basis, I think Monday to Wednesday. Is that right?
No.
Certainly that's what appears on the email
Right.
sign.
No. Jo was part-time at the time, but I think for the Calicane inspection, she came back to be full-time.
Emma Jones,
Yeah.
legal inspector, former CPS prosecutor for 20 years.
Yeah. And she'd worked on the homicide team in London, CPS London, so she obviously did have some experience of dealing with homicide-type cases, murder cases.
Is she the individual who you've described in your witness statement as coming back from retirement, or is that something?
No, that's James Jenkins.
James Jenkins. And who was James Jenkins?
James Jenkins was an ex-inspector. He'd been with the inspectorate for 6 years. He was a legal advisor in the Attorney General's office and also had previously been a senior manager in the CPS.
I think we may see him listed somewhere as an associate inspector.
That's what we call those who we bring back on associate terms, yeah.
And I think you personally led the inspection, is that right?
Yeah.
Sticking with this document, if we could please turn to page 7. We'll have a look at the remit of your investigation.
Yeah.
And it's set out at 1.3, halfway through that paragraph. It says, our remit was to examine whether the decision not to proceed to trial for murder, but to accept pleas to manslaughter was correct, and whether the approach taken by the CPS in engaging with the families during the case met the standards and expectations as set out in the Victims Code and its own bereaved family scheme. This could potentially be quite a wide remit, albeit a single case. Do you agree with that?
Yes, which is why I developed a scope as in all inspections following our methodology, and I outline in my statement at paragraph 21 the inspection question, and in paragraph 22 the scope of the inspection.
And do you see a difference between an inspection and an investigation? And if so, what is the difference between the two?
We're an inspectorate. We inspect, so we inspect against the standards that are expected to be had. We don't investigate, so we don't actually go behind the evidence to try to take our own evidence or find our own evidence. We actually look at what is available and what, in line with our scope. So we're not an investigatory. We don't have those powers. We actually inspect against the standards expected.
So essentially you look at existing documents, for example, and assess those against standards rather than seeking witness statements or additional information.
Yeah. Although we do interview as
Yes.
part of evidence gathering, but it's not interview as per investigation.
And if we could please turn to WIT in 02450006. We start on page 3. We can see that I think you met with families of the bereaved on the 9th of February 2024. Is that correct?
That is correct, yes.
And then on the 26th of February, you have received from Dr. O'Malley Kumar some thoughts regarding their interaction with the CPS, which may have affected the acceptance of the plea of diminished responsibility. Could we please turn to WIT in 02450008? And I think this is the attached document. Is that right?
Yes, we also received, I think, documents similar to this in the meeting. They were handed over in the meeting on the 9th of February by the families.
Thank you. And I'll just read to you a few sections from this complaint. The heading there is discussion with Samantha Shallow at Avon and Somerset Police and Fire Headquarters, and it says as follows. It says, myself and my husband specifically requested that the fourth psychiatrist report should focus his assessment on of Calicane's state of mind on the day and leading up to the killings. We were aware through previous mental health history that self-reporting by VC was unreliable. He is documented as being misleading and duplicitous to clinicians in the past for his own agenda, as per the previous reports. I'll just skip down to the penultimate paragraph, please. The third sentence there says, we told Ms. Shallow about advice we had received from a colleague who is a forensic psychiatrist regarding the importance of collateral history from others, and irrespective of this, she discounted our concerns as unworthy of consideration and said that she flatly refused to instruct or specify a line of inquiry upon them, even an educated and informed line of inquiry that we had specifically requested. We were adamant we felt a fresh set of eyes should review VC. And over the page, please, there's another section headed CPS engagement with the police, if we scroll down, and a section below that regarding a discussion with Mr. Kareem Khalil, KC, and the CPS. I'm going to take you back now to that series of emails that we just looked at, and that's WITN 0245006. If we start on page 2, we can see that Dr. Amali Kumar's email is then followed by, if we look at the bottom email, an email from Emma Webber. She says, we've read and noted all the comments that Sinead makes here. We were present at the meeting on the 7th of December. We confirm and agree with everything that she has said, and then goes on to provide further comment. And if we go up, please, we can see that James Coates has also followed on the 27th of February, and he says, as a family, we fully stand behind the other victims' families with the issues that have previously raised concerning the way the CPS have dealt with the whole VC debacle. And then to the top email, please, on page 1, Emma Webber has sent a further email on the 28th of February 2024. And then I'll take you just to one further email. That's WITN 0245011. The 6th of March. And this is about the case that we know as Sebastian. Further information regarding VC's stalking. If I could please now take you back to the report. So that's HMCP 40625. And thank you, this is page 1. The report is dated March 2024, but we see at the top of the page that it's embargoed until the 25th of March. I think it was published on the 25th of March. It was, yes. Can you assist us with how long before the publication it would have been sent to the printers for? It was sent to the printers on the Saturday. Thank you. I didn't Sorry. It was printed on the morning. It was sent to the proofreaders on the Saturday. And are you able to assist what date that would have 23rd. Been? Because I think, sorry, either the 22nd or the 23rd. I can't remember whether the 25th was a Monday or a Tuesday. Because reports like this, I mean, it's quite lengthy, would require... We have them printed in-house at Ministry of Justice and bound. We have an arrangement with them. And we only ever have now, because actually we lay electronically, we had enough for the families and actually enough for the team. So we had, I think, probably no more than a dozen reports printed on that morning in the print room. But in respect of the finalisation of this, it is normal to have, for example, proofreading, typesetting, yes, and that kind of thing. Yes. That would have taken place, what, on the Friday or it took place over the weekend. We worked the weekend to proofread the report. If we could please bring onto screen HMCP 40618. This is the letter that was sent to the families of the bereaved.
Yeah.
HMCPSI inspection, plans for publication and offer of a meeting on the 25th of March. In that second paragraph, you say there, I was clear when we met on the 9th of February that given the timescales of the inspection, it would not be possible to provide copies of the final report prior to a meeting on the 25th of March. Can you assist us? By this date, so 15th of March, was the report pretty much there in terms of finalisation? No?
Not at all.
So you were still going with the investigation?
Yes, we were still inspecting, we were still drafting, and we were still working. Now, we had assessed the evidence, but we're certainly in report writing stage at this stage. It wasn't complete on the 15th of March.
In terms of the timing then, I think you've said 23rd of March or thereabouts.
It was certainly over. If somebody can remind, somebody can remind me if the 25th was a Monday, and I'll be able. I'm not.
That's
sure.
fine, but thereabouts, quite soon before the final publication, it was completed. It's still under 2 months from being asked to conduct the inspection. Is that
It
right?
was very rapid.
And during that time, is my understanding correct that you had to assemble that new team from scratch? You led the inspection, presumably alongside your other work at the time?
Well, I was chief inspector. I don't inspect.
No.
So
You have managerial responsibilities that presumably you were also doing during that period?
Yes, it's a quite small inspectorate, and my dedication was actually to this report. So actually, I had other colleagues. My deputy chief inspector stepped up and took on some of the aspects of work that I naturally would have done. So I must admit my focus was entirely on this inspection.
You had, during that period, met with the families, interviewed witnesses,
Yes,
produced a report that's 116 pages in length.
yes.
Is there a maximalisation process or any sharing of a draft report with anybody?
No.
No? And then prepared it for publication.
Yes.
I think you said in your witness statement that it was sufficiently rigorous, or words to that effect. I mean, looking at the task that you were asked to do and the amount of time in which it was conducted, do you think it was less rigorous than your usual inspections?
No, I don't.
And the reason I ask you is I want to look at certain materials, and I'll take you through them. And insofar as there is any criticism of the rigour of your inspection, are we therefore to read that across to all HMCPSI reports in the sense that you conducted this in the same way as you conduct all other reports?
Absolutely.
If we could go back to the report then, please, HMCP 40625. And we'll start on page 7. If we could look at paragraph 1.4, please. You said, to conduct this inspection, we had access to all material relating to the case and were able to interview all who had dealt with the case on behalf of the prosecution, including the first prosecution psychiatric expert. Can you assist us? What did you mean by all material relating to the case?
So we had access to the full file of evidence, which the CPS had access to, which obviously includes the police papers. We had access to Crown Court DCS, where actually all of the papers are lodged for the case with the court. And we also helpfully had access to all of the FLO logs, the Family Liaison Officer logs, relating to the bereaved families.
And what about things like internal emails between
All of those,
CPS?
yeah, everything.
You had full, free access to all of the CPS's internal
Yes, absolutely. It's one of the things that HMCPSI is very lucky. We have full access, bar those cases that are closed to normal people, as in normal prosecutors. We have full access to everything on the CPS case management system.
And you've been provided with a bundle of materials prior to coming today. That included documents such as the report by DC Beddoe.
Yep.
It included phone analysis documents, a picture of a dead animal, for example.
There are only two, so in the supplementary bundle I got on Friday evening, which I think at the front had about 50 documents in, 50-odd documents. I think there are only two documents that we don't think, and it's think, I can't absolutely clarify, that we haven't seen. and they are documents, I think, 54 and 55.
And are those, I think, witness statements?
No. The witness statements we hadn't seen, obviously, because they were written after the inspection. They relate to two aspects of probably a mental health assessment at Rampton, I think, or wherever VC was. And it's 2 pages within this document, this bundle, which we may have seen them, because actually, as you may realise, doing an inspection like this, not every inspector sees every document. And the only inspector who's left in the inspectorate, Joe Milner, didn't actually look at the mental health aspect. Richard Whittam looked at the mental health aspect.
Thank you. So Richard Whittam was charged with looking particularly at the mental health aspect, was he?
Emma Jones looked. We all look at all documents, not all documents, but most documents. But Emma Jones had specific responsibility to look at the case, the previous CPS case, which is covered in Chapter 7 in the report, the assault emergency worker. Richard Whittam was looking at mental health, along with James Jenkins, because they were the two who were more experienced in that, of course, Richard being first senior Treasury and a KC. And Joe formed and looked at, sort of the handling, the victim's code element,
Was one treated as more senior than the other of those two?
Of Joe?
Richard Whittam and the investigator?
Than the associate inspector?
Yes.
No, it's a team. We all muck in and just get on with it,
You say in 1.4 that you have been able to interview the first prosecution psychiatric expert. Yeah. Is there a reason why, for example, Dr. Latham wasn't interviewed?
Yeah, we made a decision based upon, and I think it's worth saying at the outset, it actually mattered to me in terms of the values that the inspectorate has and my own values, that we actually listened to the family. We met them on the 9th of February because actually their experience of the system had let them down. I was aware of what they were feeling. I'd been told, I'd seen, I'd heard. So as part of that, there was a real concern expressed at that first meeting about some of the issues around the psychiatrist reports. And obviously we read Professor Blackwood's report. But obviously there was an issue which the families raised about, it's termed in James Jenkins' interview note of the Blackwood interview, of the back calculation, how he presented on the 13th. So we decided as a team it was worth putting the questions the family was so keen to understand to Blackwood. I felt that was the right thing to do. I didn't think we needed to do that with Latham. The report from Latham was on a different basis, and we outlined that in our report. But I did think it was probably quite helpful to talk to Professor Blackwood about some of the family concerns, to actually allow us, within the report, to set out, with clarity, I hope, and in detail, to try to give the families some understanding of actually what they said they hadn't been able to see because people weren't talking to them, weren't giving them the full picture. That was mentioned a lot in that meeting of the 9th of February. And I thought it was incumbent on the inspectorate to set out, hence why we decided as a team to go and see Professor Blackwood.
Now, in terms of the interviews that you carried out, if we could start with the first in time, so that's HMCP 40551, interview with Samantha Shallow on the 13th of February. We then go to HMCP 40552, that's with Alan Murphy on the 14th of February.
Yep.
We then go to HMCP 40575, that's an interview with Michelle Mannion on the 14th of February.
Yep.
Then HMCP 40576, an interview with both prosecution counsel.
Yep.
And then HMCP 40629, we get to Dr. Blackwood's on the 29th of February. And then HMCP 40609, an interview with Janine McKinney on the 5th of March. In terms of our timeline, Samantha Shallow, Alan Murphy, Michelle Mannion, and both prosecution counsel have been interviewed before the time that we saw that very first email from Dr. O'Malley Kumar. I appreciate that you had met them already on the 9th, but you hadn't yet received those emails at the time.
But we had to have papers handed to us in that meeting.
Yes, but that wasn't the question. The question was you hadn't received those emails.
No, I hadn't received those, but we had similar points being raised in papers that were handed to us in the meeting.
Because one of the concerns raised and detailed in depth in one of those emails were concerns about, for example, Ms. Shallow, and that was in the email of the 26th of February. She had been interviewed by the time that had been received. That is a factual
Yes, that is a fact.
position.
Yeah.
Were there follow-on interviews after that information had been received? No. Further questions posed in writing?
No.
I think as we saw in that letter to the families about the publication, in fact, other than that 9th of February meeting, there was no further meeting other than on the day of publication. Is that right?
That is right.
And is it still your position that this inspection was as rigorous as your usual?
Yes, that is.
If we could go back, please, to the report. I'm just going to look at the findings now. HMCP 40625. We start on page 7. We have at 1.5 headline findings. So the first headline finding relates to the charge, and that's essentially that the charging decision was correct.
Yes.
We then get to the acceptance of pleas to manslaughter, and essentially, again, the acceptance of the plea, your finding was that was correct.
Absolutely.
And it says the CPS could not have proceeded on the murder allegations because of the clear and unambiguous findings of the prosecution and defence psychiatric reports, that the offender's actions were because of pure psychosis that substantially impaired his ability to form rational judgments and to exercise self-control. If we scroll down to 1.10, you set out there essentially that it would have been a different position if the law had been different.
Yes.
Do we read into that final sentence there in 1.10 that you consider, or HMCPSI considers, that the law should change?
It's not a matter for HMCPSI. What I was setting out was the view that it is very difficult, I think, for anybody to accept in the circumstances of this case and others that I've been written to since, that their loved ones have been killed by someone and it is a manslaughter. You know, that word murder is something that is very important to people. You know, people, as I say, since this case, I've been asked by a number of families to look at cases of very similar circumstances. But it's a matter for Parliament whether they adopted this. But I think what I was pointing out was that actually it's a very difficult legal concept for ordinary people outside of the system to understand, and it would have possibly have been more understandable and a little bit more acceptable is the wrong word, but that's the word I'm going to use, if it had been second-degree murder, not manslaughter.
The conclusions then address CPS engagement with the families.
Yeah.
The first paragraph there, 1.11, generally you found that the CPS met their obligations to the bereaved families under the Victims Code and the Bereaved Families Scheme. Is that right?
That's right.
And then you address some things that you consider could have been handled better.
Yes.
And I'll just take you through those. So the first bullet point there, the introductory letters included standard paragraphs about the legal proceedings which may not have been understood or well received by grieving families. Over the page, please. The Family Liaison Officer is the conduit through which all CPS engagement is handled. In this case, the first CPS letter to the families was dated before the first hearing date, but was delivered after it to each family by the FLO, and thus was out of date when received. Then, where FLOs are being asked to explain legal concepts to bereaved families, it would be good practice for the CPS to provide them with case-specific written guidance. In this case, the family's understanding of diminished responsibility may have been aided at an earlier stage had the CPS provided a form of words for the FLOs to use. Just looking at those top two on the page, is this conclusion a criticism of the FLO, or is it a criticism of the CPS, so far as you see it?
So actually, having read the statements in the additional bundle, I am now aware that actually, I think it was DCI Gould's statement said that actually the letters were delivered late because of the FLO problem. Looking at this through the eyes of my inspection from the CPS, I thought, you know, given the circumstances, the CPS could have worked with the police to make sure those letters were delivered in a timely way. Also understanding, though, that it was Father's Day, I think, the weekend when those letters were being delivered.
So in respect to that first bullet point where it says...
I think what I would expect is better liaison between the CPS and the FLO to be able to get it right.
And does that suggest, therefore, that there is implied in that a criticism of the FLO for not sufficient?
No, I think it's a criticism of the joint prosecution team, as I see it, which is police and CPS are a prosecution team.
Thank you.
And I think the second one's a clear point to the CPS to consider, which is providing case-specific written guidance for difficult concepts. FLOs are not always, and you see it in the, again, DCI Gould statement, the experience of some of those FLOs was not as great as she would have liked herself, I think, and asking them to explain legal concepts, I think, is probably asking a lot when their expertise is support, not the law.
We then have two further conclusions. Two of the families were invited to a meeting with the CPS and Prosecution Counsel on the 24th of November to discuss the psychiatric evidence. There were further meetings on the 7th of December and 15th of January with the same two families. There's no record of the third family having been specifically told about those meetings, which led to a feeling of being left out and overlooked. Is the focus there on the CPS rather than the FLOs?
Yes.
And then the entry below, the CPS used the word consult on a number of occasions when referring to engagement with the families, and essentially there's no obligation to consult, and it should have been informal.
Explain. Yeah.
And then we see below that the recommendation.
Yeah.
The recommendation is by October 2024, the CPS must undertake a review of all guidance relating to victims' engagement to ensure that all staff are aware when use of the terms consult or consultation is appropriate. Have you had contact with the CPS subsequent to that to ensure that that recommendation has been taken on board?
Yes, we have a recommendation tracker for all recommendations in the inspectorate, which we follow up all recommendations quarterly. That recommendation has met. I have evidence that they changed all legal guidance where that word was used inappropriately or incorrectly. So yes, we did follow it up, and this, yes, the CPS have met it. It is a closed recommendation on our tracker.
And can you assist us with why there's only one recommendation? I mean, we've seen, for example, the conclusion that case-specific written guidance should be provided in respect of something like diminished responsibility. Why doesn't that feature as a recommendation?
Because it's case-specific. Recommendations are wide-reaching across the whole of the CPS. This is a case-specific, so each case should be on its merits. It may not be warranted to be doing it in every case, and to make a recommendation would make the CPS have to do it, because obviously they have to respond to our recommendations. So
is your suggestion not that in every case of diminished responsibility there should be further information?
I think in every case where diminished responsibility is raised and it is necessary to explain, either the prosecutor should, of course, the families in all cases can meet prosecutors. You might not want the FLO. The report goes on later to say it might be a good idea for prosecutors to meet the families and do it. So therefore, actually, it's a case-specific, so therefore it doesn't warrant a recommendation.
Is it in your view, then, that that can't be formulated in some way that could form a recommendation?
Yes, it is my view. That's why we did not make a recommendation.
I want to look then at the first substantive issue in respect of matters raised with you, and that is the complaint regarding the psychiatric reports.
Yes.
If we stick with the report that's currently on screen, please, and if we turn to page 17. This section is headed as follows: concerns relating to the CPS decision to accept guilty pleas to manslaughter. And it says, whilst the bereaved families acknowledge that the 4 psychiatric experts found that the offender was suffering from a recognised mental illness at the time of the commission of the offences, which afforded him a partial defence of diminished responsibility, they had concerns that this was not a properly reached conclusion based on the following. And there's a series of bullet points. The first is the psychiatric experts did not adequately consider and assess the offender's presentation at the time of the commission of the offences, but placed too much weight and emphasis on the offender's presentation when they interviewed him some months later and at a time when his mental state may have deteriorated due to his incarceration. And the second relates to the fact that a mental health assessment was not deemed necessary whilst he was in police custody. In particular, that first bullet point, is that something, following the conversation with the bereaved families, you were aware was a significant concern of theirs?
Absolutely, which is why it's in the report.
And that criticism isn't actually just of the CPS, is it? That's a criticism also of the experts that carried out the assessment.
Yes, it is. Yes.
And who did you interview to determine that issue?
Well, we interviewed Professor Blackwood on that very issue, and obviously saw the papers from the CPS, which then asked the question in November, after it was raised again, about why he didn't interview witnesses, how he'd made, and whether he'd considered the presentation at the commission of the offences.
And as we've already discussed, you didn't interview Dr. Latham.
No, we didn't.
You didn't interview, for example, any independent psychiatrists.
No, we didn't.
Because that's not.
That's not inspection. That would be an investigation. Yeah.
The interview with Dr. Blackwood then was presumably quite important in the overall context of determining that issue.
Yes, which is what I said earlier.
Because his methods were being called into question.
Yes, they were.
Could we please return then to HMCP 40551? This is the interview with Samantha Shallow, and we see there, in terms of who is present, we see Richard Whittam, Samantha Shallow, and then you have your investigator, I think.
Inspector.
Your inspector, thank you very much.
So we have 3 inspectors in there: Richard Whittam, Joe Milner, and Emma Jones.
Thank you.
Scarlett Johnson is a CPS note taker.
And then if we go to the next interview, HMCP 40552, the Alan Murphy interview, similar cast list. We have Richard Whittam,
James
Joe
Jenkins,
Milner.
Joe Milner.
Emma
Actually,
Jones.
we have all 4 inspectors in that one.
Yes.
Yep.
HMCP 40575, Michelle Mannion, again Richard Whittam, Joe Milner, Emma Jones.
No Emma Jones on that one.
Oh, thank you. Joe Milner and James Jenkins.
Yes.
HMCP 40576, the interview with Prosecution Counsel. Richard Whittam, James Jenkins, Emma Jones. So 3 members of your team.
Yeah, 1 taking notes.
And then HMCP 40629. This is the interview with Dr. Blackwood.
Yep.
It's described as a conversation with Dr. Blackwood. Can you assist us with why it's described as a conversation?
I presume the note taker, Joe Miller's, called it that rather than an interview.
Was it over the phone or in person, so far as you can recall?
I think it was over the phone.
Over the phone. And we have there James Jenkins, Joe Milner taking notes. Richard Whittam's not present at this one.
No, he's not.
I think you had previously said that Richard Whittam...
And James Jenkins were leading on mental.
Yes, but Richard Whittam was involved in the psychiatric side of the complaint.
He was, of the report, yeah.
Can you assist us then in respect of such a significant witness, in fact the only psychiatric witness that is being interviewed, why Richard Whittam isn't there and why it's a smaller cast list?
It's availability of Professor Blackwood and Richard Whittam. There was a clash, it didn't work. Richard actually was on holiday at that point, and it couldn't be changed. We had obviously the pressure of time, and actually all inspections, the reason for a note and the reason actually for the interview, we come together and we discuss the evidence together as a team. So actually Richard would be fully appraised as part of the inspection process. And he will have helped. I know James and Richard prepared the questions together, and actually they were provided to Professor Blackwood before the, as Professor Blackwood's statement said, to the inquiry before the interview.
As former First Treasury Counsellor, it would have been helpful.
It would, but he was, as I said, on holiday.
Yes, and then I'll just read to a couple of the questions. Mr. Jenkins starts, before we start, with the specific questions I have previously sent you. Is there anything you want to mention that you think is important and not covered in what I sent you? Can you assist us with that? Are interviewees provided with the questions in advance?
Sometimes, sometimes not.
I mean, is it usual in your investigations for inspections for a significant witness to be provided with the questions in advance?
Depends sometimes. It's not unusual.
Professor Blackwood then responds and he says, just that the family's concern also seemed to be the delay between me being instructed and me seeing and assessing the offender. So he raises a further issue that wasn't addressed in the questions that had been sent. Did you obtain any independent evidence in respect of whether it would have been beneficial for Professor Blackwood to have seen VC earlier?
No.
And if we go over to page 2, please, I'll just read to you an exchange between the interviewer and Professor Blackwood. He says, regarding the materials, you were given a lot of material from the CPS. Do you essentially make your own judgment of what to read, or do you read it all? And then Professor Blackwood says, no, I look at everything I'm given. You're not immune to error, so you may miss the odd line, etc., but that would be pointed out by barristers or further questions posed from the CPS. As here, the families pay particular focus to the defendant speaking to the security guard outside Seeley House. I had obviously been aware of this interaction, but I was further prompted to consider this by the CPS. I was asked if the security guard should be further interviewed by the police or should I myself interview him. So this is an example of where I was prompted by the CPS to look at the materials again. I responded that I did not seek to interview him. I've never done so in the past and cannot think of colleagues who would speak further to such a witness like this. And then the interviewer says as follows. He says, is it fair to say you were quite satisfied from all the material you had, plus speaking to the offender, that you were in a position to make a rational and reasoned assessment to his mental state at the time he committed the offence? Is this typical of the kind of question that might be posed by HMCPSI in an interview?
Yes, it is.
It may be suggested that's not a particularly probing question.
Maybe. That's why, we find from all of our interviews that actually a conversation, as this note is actually titled, is much more able to actually get to the nub of the issue, because not only does it put the person at ease, but it also allows you to follow hooks as the evidence comes out. That's the approach. If you came on our interview training course within the inspectorate, that is one of the techniques we use. So we try not to cross-examine, and we don't purposely cross-examine, and we don't try also to trip up. Now, if the person being interviewed becomes difficult, we obviously change our technique. But generally, this is the sort of question, and you'll have seen in the other interview notes that actually these are it's a general approach in HMCPSI when we are talking to people to gather evidence, that we do it in a very open and constructive way.
So is that again something that distinguishes you from an investigation?
Yeah, absolutely.
In the sense that this is it's in fact called a conversation, yeah, and the questions are not particularly probing.
Well, I wouldn't say they're not probing. I think we're getting to the heart of actually some of the issues that were raised, which actually also, try to address some of the family concerns. Did Dr. Blackwood, from the material, make a rational and reasoned assessment to his mental state at the time that the defendant committed the offence? That was one of the concerns that the family absolutely had, and we ask a question about it.
I mean, that summary, though, provided that I've just taken you to, is it fair to say, I mean, that's essentially summarising what Dr. Blackwood has said and said, is that right?
And he also said it in further papers that we had seen after had that question posed in November.
And if we look overall at this conversation, it's only 4 pages long.
Yep.
Do you have an idea of how long?
Yeah, I think the interview is about half an hour.
About half an hour. If we go back to the report, please, so that's HMCP 40625, page 52. Page 52, you have findings in respect of the psychiatric expert.
Yeah.
It says as follows. It says, in relation to the first prosecution psychiatric expert's report and finding that the partial defence was available to the offender, the expert confirmed to us, 1, he had been retained at an early stage of proceedings. 2, his approach was guided by the material that was made available to him. If we scroll down, please. Thank you. 3, he's considered whether the offender had either fabricated his mental illness or that his illness had deteriorated whilst he had been in custody. 4, even if the offender's condition had deteriorated later, his psychosis persisted at the time of the offences. 5, there was no inconsistency with the offender being assessed as fit to be detained in later diagnosis of diminished responsibility. The next one, 3 of the expert psychiatrists, including himself, had concluded that the offender was not insane. Over the page, please. He has taken into account the evidence that suggested that the offender could exercise some self-control, and there are further bullet points. I think perhaps I'll read to you the very final one. The first prosecution psychiatric expert had taken into account previous assaults, including the assaults of his co-workers, police and housemates. These all occurred when the offender was under the influence of untreated psychosis. What seems to have occurred here is that Dr. Blackwood has, it says here, the expert confirmed to us. He's essentially been asked to provide his account. Am I right in understanding that HMCPS, perhaps because of your role, perhaps because of your resources, or some other reason, please do tell me, don't set out to test the account that is given to them by what is identified there as the psychiatric expert?
Yes, I think the point is, he is a psychiatric expert, we are not. We're inspectors, lawyers, and, you know, in a way, it's very difficult, I think, in any sphere of life, to be saying, I've now become an expert in psychiatry, so I'm going to test you on your findings. And so we challenged Professor Blackwood on the basis of the family's concerns, some of those concerns which are outlined in Chapter 3 of the report in detail, to try to understand whether he had considered some of the things that the family said to us they were concerned hadn't been considered. But we are not psychiatric experts. None of my inspection team who spoke to Professor Blackwood, and none of us are psychiatrists. And it's the same for any expert, I think, in any walk of life. You know, we are doing a job trying to test the evidence that the CPS had. We've seen all the evidence the CPS had, and we have come to the point, and again, I take you back to the fact that I wanted the families, it was at the heart of this inspection for me, to know what had been said, because they said on numerous occasions they were in the dark. We tried to outline what Professor Blackwood had done and what he thought. And that is why this is in this report. This report could have been probably a lot shorter. I purposely made the decision to actually do a very full report to try to set out what happened in this whole case so that the families could understand.
What you're essentially doing, though, is you're putting the family's case to the expert, but what you don't have is sufficient material to test the expert's own response, do you?
No, I don't.
No. And if we look at page 54, paragraph 6.35, the finding there is the first prosecution expert was an eminent forensic psychiatrist. His conclusion was clear and unambiguous. A plea of guilty to manslaughter by virtue of diminished responsibility was appropriate. That report considered countervailing arguments. It's clear to us as a result of our meeting with this expert that he had taken into account the concerns that had been raised by the bereaved families about the assessment of the offender's mental state on the day of the attacks. Are we really to read into that the caveat that we've just discussed?
We asked about that. James Jenkins' interview note, as you see, talks about a back calculation. You know, I am not going to get behind, and I don't think anybody should, you know, saying that Dr. Blackwood wasn't the expert in his field. He told us he'd done it. We're not experts. We don't investigate. We didn't ask an independent psychiatrist. So, that is our judgment. That is the judgment that actually he'd thought about it. He said he'd done it. And we therefore make that finding.
As we discussed towards the beginning of your evidence, part of the complaint wasn't just about the CPS's handling of the complaint, it was also actually about how the expert reached his own opinion. Realistically, that's not something that...
That's out of the scope of this inspection. Realistically, that would, I presume, there will be some governance of psychiatry. I don't know who does it, but if, that's the issue. If somebody's saying that Blackwood's got it wrong, then actually they should be investigating through the line, and it is not nature. That is not the scope of this inspection.
Thank you. And then moving on to a second topic briefly, and that's the family liaison officers. If we could go, sticking with this report, if we go to page 9, please. We saw there that those first two bullet points in the headline findings relate to the FLOs, and I think you've said really it's not actually a criticism of the FLOs themselves. Could we please turn to page 61? We have here the section relating to the Crown Prosecution Service's obligations to victims and bereaved families. If we go over to page 65, we see in the bottom of that page the role of the family liaison officer. Page 67, please. This is the beginning of the section of the Crown Prosecution Service's engagement with the bereaved families before the decision to accept pleas to manslaughter. And if we have a look, please, at page 69. Paragraph 9.10, you say, we've considered the contact that the CPS had with the bereaved families, both directly and indirectly, including via the family liaison officers from the 13th of June, the date of the offences, until the 24th of November. Now, it's right to say that you didn't speak to the FLOs themselves.
We didn't.
You were working simply from their logs, is that right?
That is right.
If we continue down section 9, over the page, please. There are repeated references throughout this section to the FLOs. If we look at 9.21, for example, it says, in the aftermath of losing a loved one, in horrific circumstances, bereaved families will understandably be in a high state of shock, disbelief and grief. This is where the FLOs are vital in being the conduit and can reinforce to bereaved families as the days and weeks move on that the offer made in the CPS introductory letter to meet the prosecution team remains an ongoing offer. The CPS cannot force bereaved families to meet with them and are heavily reliant on the FLOs, who are in regular contact with the bereaved relatives, to keep them updated about the family's position and views on if and when they're ready to meet the prosecution team. We can see there below that plenty of mentions of the FLOs and their role and their involvement. If we keep on scrolling down, please, just to give some more examples. Perhaps if we go to page 73, 9.39. It says there, following the request for a meeting that was made by Barney's mother to her FLO on the 7th of November, the FLO informed the reviewing lawyer of this on the 30th of November. The FLO informed the reviewing lawyer that the request was for a meeting with the CPS and council, preferably before the PTPH, as Barney's parents wished to understand fully the partial defence of diminished responsibility and the possible outcome of the PTPH on the 28th of November. The FLO said that she and her fellow liaison officers felt that they did not have the necessary experience and knowledge to explain the legal concept and would be more comfortable if the reviewing lawyer and counsel could do so. We note that this request was made 6 weeks after the reviewing lawyer had requested that the FLOs liaise with the police investigation team regarding a strategy for communicating the contents of the first defence psychiatric expert's report to the families. A bit of a criticism of the FLO, or an implied criticism there, isn't it?
I think obviously the FLOs know the families, that's their role. I think throughout the logs we see quite a lot, understandably, of the families not really wanting to engage with some of this. However, actually, in the case of the Webbers, David Webber had asked about diminished responsibility earlier than this. So it's not really an inferred criticism, because obviously each case, when the FLO is close to the family and they know when people are ready or not ready to talk about it. It was interesting, though, that the reviewing lawyer naturally was concerned about starting to explain some of the issues which the families later became very concerned about as early as they possibly could, to start getting that out and talking about it. And it didn't happen for 6 weeks.
If we continue, please, if we keep on scrolling down, let's go to just another example, 9.49. However, in the police FLO logs we examined, we did not find any reference to Ian's son specifically saying that he and his brothers did not wish to meet with the CPS prior to the PTPH. There's nothing in the logs to suggest that the FLO discussed the CPS offer of a meeting with Ian's sons between the date of the first Crown Court hearing on the 20th of June and 24th of November, when the FLO called Ian's son to inform him that the first prosecution psychiatric report had been received and that it was likely the CPS would accept pleas to manslaughter. If we keep on scrolling, go over perhaps to 9.54, 9.55. Regarding Barney's parents' concern that they did not think that they would have a meeting with the CPS prior to the PTPH, had they not initiated it, we found evidence to the contrary. As far as the CPS were aware, from information received on the 2nd of October from Barney's parents' FLO, a meeting was to be held after the PTPH, as they were unable at the time to hear details of the offences. The reviewing lawyer acknowledged this, but told the FLO that if the family changed their mind, the CPS would meet with them. We found no record in the FLO logs to indicate that the message was relayed to Barney or Grace's parents. But as far as the CPS were concerned, from information they had received and then imparted back to the FLO on the 2nd of October, the offer of a meeting with the CPS was a continuing offer that had been extended to both Barney and Grace's parents. Up until 13th of November, the CPS had been unaware that Barney's parents had not understood the partial defence of diminished responsibility, as they had not been told by the FLO. Likewise, if the other bereaved families had not understood it, the CPS had not been informed. We then move on to the findings over the page, please. 9.57, we found that written guidance on diminished responsibility should have been provided by the CPS to the FLOs. 9.58, we found no record that the request by Barney's parents on the 9th of October for clarification on diminished responsibility had been communicated by the FLO to the CPS. And 9.60, these points highlight the importance of proactive and probing approach being taken by both the CPS and FLOs when communicating with each other. Now, looking at those passages that I've taken you to and the findings, as a matter of basic procedural fairness, do you think that the FLOs should at least have been asked for their response in advance of publication?
No, I don't.
And why is that?
So we obviously had access to the very extensive FLO logs. We had a timescale which was tight, and as a team we discussed at length whether we need to think about speaking to the FLOs. And actually, now having seen in the supplementary bundle that was sent on Friday evening the statement from DCI Gould and PC Baxter, I actually think there is nothing in this report we would have had which actually would differ from our findings. And
Have you received all of the FLO statements to this inquiry?
sorry?
All of the FLO statements to this inquiry?
No,
We've
I
obtained
haven't. I
statements
haven't. The only ones I've received were the two I got on Friday.
So based on the two that you have read, you wouldn't have changed anything?
No. But I also want to say that actually I'm the CPS inspectorate. The FLOs are police staff.
Absolutely.
I do not have the remit to interview. I could have requested, they would not have to accept, but it is outside of the remit of the inspection for me to be interviewing police staff, because I was looking at the CPS here. But what we felt to be able to do this properly was we needed to see the FLO interaction with the families to give us a full picture. And as I say, I haven't seen all of the statement, but the two I've seen, there is nothing in them that actually is contrary, I think, to our findings in this report.
Simply thinking in terms of fairness to the FLOs, you have clearly criticised the FLOs here, haven't you? You may not have named them, but there is something that they would have wished to have responded on, isn't there?
The statements that I've seen in the supplementary bundle, actually, and I didn't know this until I saw those, admits that they were at fault.
I don't think you've read all of the statements.
No, but I've read the two that I've been provided with.
You also, I think you've given an explanation in your witness statement that one of the reasons you didn't contact the FLOs was that you understood that the relationship had broken down.
Absolutely.
Did you ask the FLOs about that?
No, I didn't.
Aren't these findings really just low-hanging fruit?
I don't think so.
And if you had more time, looking back at this again, because we've discussed how quickly this was produced, if you had more time, would you or should you have contacted the FLOs to at least see if they had a response to the allegations?
I would not have, having considered it since being asked to come to give evidence, I considered that question carefully. If we did this inspection again, we would probably make the same decision not to interview the FLOs.
And very finally, I want to ask you about engagement with the bereaved and also engagement with the survivors. Let's stick with this report. If we could please turn to page 16. Paragraph 3.4, please. You say there, we invited members of the bereaved families to meet with us so that we could hear directly from them about their concerns over the CPS's handling of the case. The invitation was also extended to the 3 surviving victims, but they did not respond. Ian's partner declined the offer of a meeting, confirming in a telephone call to us that she had no concerns about the CPS's engagement with her and was complimentary about the service she received. Looking back at this, and again, looking at the amount of time and how quickly that this was produced, do you think that more effort could have been made to engage the survivors, recognising, for example, that there were serious injuries, whether it be a brain injury, whether it be PTSD?
Possibly. I think actually, on reflection, obviously, I wrote to them in a similar way that I wrote to the bereaved families through the contacts we had. I do wonder whether actually if I did this again, and I think it's on the reflection, obviously I've got the reflections at the end of my statement, that actually we could have tried to reach out again to try, but I'm not sure really, given the time we had, what more we could do over and above what we did. But on reflection, if we had more time, like the IOPC and the CQC, which had a much less demanding time scale, I think probably I probably would, because it obviously sits with my values. I think I would like to have asked, I'd like to have spoken to them to see how they felt through the process.
The letter of the 15th of March 2024, I won't bring it back up, but the one that we saw notifying the bereaved of the draft report or the report that was being finalised, or the publication of the report, was similar letters sent to the survivors, so far as you're aware? They weren't?
No.
No. I mean, it would have been...
Yes, it would. On hindsight, it would, yeah.
If we could go, please, to page 68.
Can I just say, though, you have to remember the commission from the attorney was from the bereaved families. It was the commission for this inspection was on the basis of the meeting with the Prime Minister with the bereaved families. But it, you know, again, for fairness, I didn't want to exclude the survivors, but the commission actually was quite clear.
Did you ask the Attorney General whether you could have more time?
No, I didn't. Well, I was made aware I wouldn't have more time. I didn't ask the direct question of Baroness Prentice, but I was made aware that Easter was the hard cut.
On page 68, paragraph 9.2, this addresses Elaine Newton. It says, Ian's partner declined to meet with us, but confirmed in a telephone call that she had no concerns regarding the CPS's engagement with her and was complimentary about the service she received. Again, could you have done more to have engaged her? I mean, she wouldn't have known the concerns that perhaps you shared.
I had the telephone call with Elaine, and she was very clear in that telephone call. She was very grateful for the call. She was very grateful for what we were doing, but she was very clear. She didn't want any contact about this in that telephone call to me.
And in none of your inspections do you inform those who are affected in advance of a summary of your findings?
We don't do inspections like this. This is a unique inspection. There's only ever been in the history of the inspectorate 2 specific case inspections. One was on the Jubilee Line inquiry, and this one. This is a very, very unique inspection. We do not look, and have not looked, bar this and Jubilee Line, at individual cases.
And looking back at this, just as a criticism may be made of the CPS and their engagement, do you think that HMCPSI could have spent a bit longer and have engaged a bit more?
Yes, I do, which is why I said it at the end of my statement.
Thank you. Chair, I don't have any further questions. There are questions from core participants.
Yes, thank you, Mr. Maloney.
Morning, Mr. Rogers.
Good morning.
Just 3 topics, if I could, please. First of all, the report of DC Beddoe. Secondly, Dr. Latham's instruction. And thirdly, the publication of the report. So if I could take each of those in turn. You've already set out what the remit of your report was at paragraph 1.3. Mr. Blake, having asked you questions about that, I'll ask you about Mr. Beddoe's report, if I may. Have you watched any of the evidence? Did you watch any of the evidence of Mr. Murphy, Miss Shallow, Miss Mannion, or Mr. Khalilking's counsel?
I've read the transcripts of all of those.
You read the transcripts of all of them. Thank you very much. And you were aware from your inspection of the events during the course of the investigation and prosecution that you were concerned with, and having written your report, that the family raised numerous concerns to the effect that insufficient regard had been paid to the apparently rational actions of VC on the 12th and 13th of June. And did you, I mean, I think you've already said you knew about Mr. Beddoe's report in answer to a question from Mr. Blake during the course of your the formulation of your report.
Yes, we saw the evidence, we saw the Beddoe report, we saw Alan Murphy's response on that, and we saw the correspondence that followed that report and where it came and, you know, whether it was requested or not. We saw all of that evidence.
You saw all of that, and indeed, having read the transcripts, you've seen that some of that correspondence has been gone through with Mr. Murphy and various others. Now, that report of Mr. Beddoe was placed on the schedule of sensitive unused material. Yeah. As the head of HMCPSI, is it your view that the Neil Beddoe report should have been on the schedule of sensitive, unused material?
It is communication between the police and the CPS, and as a natural course, that's where it would live. It would live on a schedule of unused material.
So I just want to explore that with you. The disclosure of Mr Beddoe's report, how would that give rise to a real risk of serious prejudice to important public interest so as to justify it being placed on the schedule?
I think Alan Murphy actually answered that question, as did Sam Shallow. And, you know, sort of in a way, we were inspecting. This was, we did not get into the management of disclosure as part of this inspection. What we thought about was actually what was in that report and actually the issue that related to that, and whether obviously the psychiatrist had considered some of the issues, which I think we all realise that they did understand the issues that was raised in that Beddoe report. Right. We were not doing an inspection of disclosure on this inspection. Yeah.
You said Alan Murphy answered that question, and Sam Shaw. I was actually asking you, Mr Rogers, what would be the public interest that would be seriously prejudiced, an important public interest that would be seriously prejudiced by the disclosure of that report?
Sorry, I don't think I can answer that question. One, I'm not a lawyer.
And it shouldn't be on a schedule, a communication like that, should it? And if it was on any schedule, it should be on a non-sensitive schedule.
It's a memo between, the norm is, but to my understanding, the norm is, I'm no disclosure expert, that a memo between the police and the CPS of that nature would live on a sensitive schedule.
Can I ask you to have a look at an email, which is CPSC 309097? And this is an email in response to Mr Murphy's email, which I'll describe in shorthand as a critique of Mr Beddoe's report. Yep. And you saw this email?
We did.
Yeah. And you see there that it reads, "Hi Alan, I entirely agree with the below. I'm also far from convinced with Lee's response. If it wasn't to set out the police view as to the acceptability of the pleas, and I don't understand the point of it, and specifically that it is not possible to say with any certainty opinion aspect. I hope that your last sentence got the message across to the police about sharing this view with the families. I'm very concerned that this may have been or will be done, whether in the form of the report or in discussion." Did you ask junior counsel about that email?
I'd have to look at the notes of the interview. I'm sorry, I don't. Can you bring up the notes of the interview that we did with junior counsel and Mr Khalil, please?
We can check that. Do you recollect asking?
I recognise this email. I can... Let me have a look at the notes. Sorry. I don't know if we did. Somebody point...
If you got it there.
Yeah, the URN is HMCP 40576.
Mr Rogers, it's going to come up on the screen.
Thank you. Can you scroll up, please? Or down, whichever way it goes. Sorry. Keep going. Sorry. Keep going. It doesn't appear we did.
No. But does that email not... did that email not concern you that counsel was concerned about the police sharing this view with the family?
I think given the concern that was expressed where that report had come from, nobody was clear why the report had been produced, and actually it was contrary to what the issues in the case were. I think it probably would have caused more disquiet, confusion and upset. So I actually think it was appropriate not to share that with the families, because I'm not sure the report actually...
I didn't ask you that, Mr Rogers. I asked you whether or not it concerned you. whether or not you thought at the time, actually, this might reveal a little bit of tension about the families. And part of my remit, if I can just read, is that whether the approach taken by the CPS in engaging with the families during the case met the standards and expectations as set out in the Victims' Code and its own bereaved family scheme. Were you not concerned by this, that there might be an apparent tension as perceived by junior counsel in terms of firstly, what the police were trying to do, and secondly, that revealing information to the family? Not what you think now about whether or not it was right, but whether or not those tensions emerged from that email.
I'm not quite sure how that would actually sit within the scope of the inspection, looking at actually meeting the bereaved family scheme or the Victims' Code of Practice, which actually is what the... So I may be misunderstanding your question, so please forgive me.
Were you concerned about the relationship between the families and the CPS during the course of this investigation and prosecution?
I was concerned that actually the CPS, as part of the inspection, it was very clear that the CPS had tried their best to engage, inform, consult, speak to the families throughout. And it was quite obvious, I think, as part of this inspection, that there were different expectations and understanding of a lot of issues.
Right. So, if the CPS had been seeking to, you reached that conclusion, that's what you've said now, CPS were concerned to engage the families, and I don't want to...
I'm not saying they were concerned to engage the families. I didn't say that. That's not my words, I don't think. Or if I did, I certainly misspoke.
It was very clear that the CPS had tried their best to engage, inform, consult, speak to the families throughout. Engage was the word you used. Did this not show a concern about further engagements with the families on the part of the police by telling them about DC Beddoes' report?
I don't think so, no.
Right, OK. I'd better move on, because I've got just... If I can just ask you very briefly about the... publication of the report. Did you inform the families of the date of publication of the report, the 25th of March?
Yes, I did.
Yeah. And you offered a face-to-face meeting with the families on that date?
Yes,
I did. And you declined to provide them with advanced copies of the report because of embargo considerations?
No, because it was physically impossible to do so.
You sure it wasn't embargo?
Yes, no, it wasn't the embargoed basis. It was physically impossible to do so, as I said to counsel to the inquiry.
All right. And you're sure about that?
Absolutely.
OK. Now, you met them on the morning of the date of publication?
I did. We did.
The report is 115 pages in length with appendices, isn't it?
Yes,
And you allowed them less than an hour with the report before meeting your team, didn't you?
No, I didn't. We had a meeting for over an hour and 3/4. That meeting actually delayed my speaking to the press. My briefing to the press was delayed by 2 hours, and we spent an hour and 3/4 trying and going through the report with the families as a team.
I'll put to you that you allowed that after that time of just short of an hour, they went straight into a meeting to raise any questions that they had, and then at the end of that meeting, in about 45 minutes, you did your press conference, didn't you?
I did my press conference at 1:30, having left that meeting with the family speaking to the press outside of the building.
Thank you very much, Mr. Rogers.
Yes, Ms. Cartwright. Morning, Mr.
Morning.
Rogers. I ask questions on behalf of the survivors. Could I go, first of all, please, to essentially the request for the inspection that you undertook? So it's in HMCP 40625, at page 99, please, which is the commissioning and the inspection. Thank you. Thank you. Now, you've indicated that the remit was only for the bereaved families, not for the survivors. And looking at this request from the Attorney General, why do you say it did not apply to the survivors, bearing in mind this was a rapid inspection of CPS actions in the Callacane case, the survivors were part of that Callacane case. And you see, it says, this inspection should address the concerns raised by the victims' families about the charging decision and the approach taken by the CPS in engaging with the families.
Yeah, I said that because of actually the Commission and the conversations had related to the conversation that the bereaved families had with the Prime Minister and the Attorney General and others at that time. But obviously I agree with you, which is why we wrote to the surviving families to ask if they wanted to engage with this inspection.
You say that you wrote to them. There's not been provided in the disclosure, the letters.
Right. We did write them.
Well, one would have expected if the Inspectorate has complied and provided full disclosure to this inquiry, they would be there.
I don't know why that wasn't included.
So certainly the report records at paragraph 3.4 that they're invited to contribute, but certainly those I represent and their lawyers have no evidence of any invitation to engage with the inspection. And so it would first of all be of assistance if those letters or the approach could be disclosed. But because certainly from our perspective, there is no evidence whatsoever of any contact with the survivors to engage with this inspection. And would you agree that even if you are correct that a letter was sent, which we've not received and not received in disclosure, that one of the failings in this inspection is you have failed to capture the input from survivors who have some very real evidence and input about the CPS engaging with them as victims?
I think I answered the Council to the inquiry that actually, in hindsight, I think I would have done it quite differently.
No, well again, it doesn't require hindsight. And perhaps whilst we're looking at that, just to contextualise what you've said in your witness statement, please, if we could just disclose your paragraph 52, I think it is, in the witness statement, where you effectively, thank you, can we move to, I think it's paragraph 52. Thank you. Paragraph 52, please. You say, I consider that the inspection report fully addressed the concerns raised by the bereaved families in respect to both the CPS decision-making and the CPS communication with them. There is nothing further that I consider we could or should have done. This is in respect of responding to the remit of the Commission received from the Attorney General addressing the families' concerns and in reaching the clear findings that we did. Would you agree, or would you now therefore amend your paragraph 52 that essentially there is more that the Inspectorate should have done in respect of the remit of the Commission?
Yes, I would.
And I think even leaving aside the complete failure to engage with the survivors, can I just push back on your paragraph 52 in terms of that observation, bearing in mind you yourself have said you were given limited time to complete this inspection. There was no pre-publication discussion or disclosure, and therefore would you agree that those two are also failings in this inspection that really don't deserve the pat on the back of there's nothing further that I consider we could or should have done? Well,
I do consider what more we could have done. I set those out in paragraphs 53 and 54. But yes, I agree with you on reflection. If we had had more time, we would have engaged. I would have probably tried to have engaged with the survivors in a more meaningful way than sending a letter and not getting a response.
Well, then, can we then perhaps just look at the purpose of inspections? It's document WITN 0245002. Thank you. And certainly in terms of the principles for the inspection, if we look at principle 1, the purpose of improvement, I'm going to suggest to you that a rushed inspection or inspection where there plainly were significant issues from those that I represent in respect of communication that are not just fact-specific, that will assist more broadly the CPS engagement with victims who have traumatic brain injuries, post-traumatic stress disorder and physical disabilities as a result of the attacks on them. that there was a real opportunity for improvement more broadly as to how CPS engage with victims if this inspectorate had undertaken what we say should have been done, the views and specific look at the perspective of the survivors. Would you agree?
Yes, I would.
And then if we can just go down, please. Again, in terms of an inspection, what is key is the user perspective, principle 3. Inspection should be delivered with a clear focus on the experience of those for whom the service is provided, as well as an internal management arrangement. Inspections should encourage innovation and diversity and not be solely compliance-based. I think you've already accepted that this inspection completely fails to have the perspective of the survivor victims as to how the CPS engage with them. Would you agree?
I do, but these principles are actually about what I would call usual inspection. As I've said already, this is a unique inspection looking at one case. Inspection actually is very unusual of this nature. We normally focus on the experience of a cohort, so be it, you know, we've just published an inspection on the CPS performance of those involved in knife crime or crimes against older people. So the user perspective is a much wider view. In these principles, these 2003 principles, what you're saying I agree with from the point that I could have engaged with the survivors, but that user perspective, I think, is not as you've just set it out because of the unique nature of this inspection.
Well, what I'm going to suggest to you is not just fact-specific matters, but one of the matters you've robustly said in questioning today, there would have been no purpose in speaking to the flows, that essentially they are police individuals in any event, so they may not need to cooperate with our inspectorate.
No, I don't have a remit to inspect them. I didn't say not cooperate. They may check that they could have refused. I can't make them talk to me.
Because what I'm going to suggest is it was a real opportunity for the inspectorate to look at how the CPS rely or absolve their responsibilities by saying, well, that was for the flow to sort. Because perhaps if I give you a context, those that I represent were asking for meetings along the way to understand, and in particular Wayne and his partner, and the evidence that has ultimately been given about those requests for meetings is, well, the flow should have sorted those meetings. And so where the CPS rely upon the flows as a conduit to discharge their communication responsibility, there's a very real issue.
There is.
That affects nationally.
It does.
How CPS essentially are discharging their obligations in the victim code relative to essentially saying, well, it's down to the flow. And so that's why I'm going to suggest this inspectorate lost a real opportunity to provide national learning about the CPS not being over-reliant on flows.
I don't actually entirely agree with that because we published a report on meeting the needs of victims, a joint report with HMI CFRS, the Police Inspectorate, only 2 years ago, pointing to the exact issues in this case. So I don't agree. We did miss an opportunity here. I agree. From the survivors, we missed an opportunity. But actually, I don't think, because of the work that we do generally through inspection, we published a report only 2 years ago highlighting the issues you're just talking about.
Well, even more so, though, in the context of the fact specifics of this and the failings in the system, there was a real lost opportunity. Because, again, even in this opening to this inquiry, the CPS wrongly in their opening indicated the survivors had 2 flows. There was 1 flow for 3 cohorts of survivors. And again, lots of evidence of ways there where actually the guidance could have been better given to assist victims, and particularly victims who sustain cognitive injuries, brain injuries and physical disabilities. Would you agree?
Yes, having read the statements of DCI Gould now, yes, I think there are opportunities, but I don't think that's entirely a matter of, I think that's more a police matter than a CPS matter, if I'm perfectly honest. The allocation of the FLO.
Well, I'm going to suggest that's just why in this case there was rich learning on the facts of this case if the flows had been spoken to, and particularly the single flow, who all of her records were not in the flow logs you saw. They've been lost and destroyed in Teams meetings, and who described herself as on the outer circle of the flows.
Right, okay.
Thank you.
Thank you.
Ms. Carey? Yes, Mr. Rogers, I just wanted to ask about one thing. You said here this wasn't a usual type of inspection because it was one of two different, as you said, unique inspections. One was the Jubilee line, very different to this.
It was, yes.
And this is a complex case involving murder, the defences, and attempted murder, and the intersection of that. So you've got different groups, haven't you, that you're looking at, and the treatment of those groups, the victims, the bereaved, and the survivors, all of whom have different needs and interactions with the police and the CPS because of the nature of their involvement. And you make one recommendation. You were asked by Mr. Blake about whether it would have been possible and right to have made a recommendation about written advice being given to the flows. Now, why can't that be done? It may be that you have a number of different, as it were, short cards that they have. So the difference, for example, between the position of those who were the victims of attempted murder, because that still affected them. The decision in relation to diminished responsibility would affect the outcome in terms of the sentence.
Sentence, yes, yes.
So that would have been something which could have been explained really relatively simply, although these are complex matters, aren't they?
Yeah, I think I tried to explain to counsel, to the inquiry chair, that this is quite a unique case, and if we make a recommendation like that, the CPS, obviously, through the processes we have, superintendents of the attorney, would be obliged to do that in every case. And I'm not convinced that there was enough evidence in this case for me to be able to say, as Chief Inspector, that we should recommend it as national, as CPS policy.
Why
no,
not? Because I'm interested in why not, obviously.
I think this inquiry could lead to that. I just think that actually, I would like to have seen in the Manchester bombing, in some of the Southport case, I'd like to have had some other evidence about whether that issue was so core in multi-murder, multi-survivor, cases of this nature, before I made a recommendation. Making a recommendation, now the one on consult was clear to me, and was a recommendation. The CPS were wrong in that, around evidential issues, they're not consulting, they're informing. But actually, I would have wanted a bit more evidence before I made a recommendation that the CPS should. But actually, there's obviously your inquiry, there's nothing to stop you from making that recommendation. I think it will be, why we put it in the narrative is we thought it was a very sensible thing to do as a finding, but I didn't go as far as a recommendation for the reason I've outlined.
Well, I'm interested as to the process whereby you didn't, because obviously it's a question of your remit. Because in one sense this was a paradigm case in which you could have done that, couldn't you?
Possibly, but as I've just said, I would probably, to make a recommendation, I would have liked a little bit more evidence.
Yes. All right, thank you.
Thank you.
Thank you, Chair. Just as a matter of technicality, I think in my rush to get on this morning, I don't think I asked Mr. Rogers to confirm the truth of his witness statement. Could I just ask you, you produced a witness statement, WITN 0245001, dated the 27th of February 2025. Is that true to the best of your knowledge and belief?
It is. Thank you.
Thank you very much.
Mr. Rogers, just before you go, I don't want to have to make a specific request, but if you do have letters that were sent to the survivors, will you provide those to the inquiry?
I'm very surprised they're not in what we provided, because I think I asked for everything to be kept.
Thank you.
But I will check
do
again.
Another search to make sure that we have everything. Thank you. Yes.
Chair, may I call Dr. Lloyd, please?
Please stand. Please repeat after me.
I do solemnly,
sincerely and truly
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. Please sit down.
Dr Lloyd, you've prepared a statement for the inquiry dated the 18th of December 2025. Can you confirm the contents are true and accurate as far as you're concerned?
There are two small areas of inaccuracy. Paragraph 342, there's a date inaccuracy, a date that reads the 4th of July 2022, which should be the 4th of August, when Mr Carter and Paul Robinson did their visit.
Yes.
And there is a further inaccuracy in paragraph 346, when I mentioned that Gary Carter was present at the meeting on the 22nd of September 2022.
The discharge meeting.
That's correct, at that meeting, but in fact I have come to learn that he was not present.
How have you come to learn that?
It was through reading his witness statement.
Thank you. But subject to those amends, you're content it's true and accurate as far as you're concerned?
Yes.
Can you tell us, please, your qualifications and experience and indeed your role at the time of dealing with VC?
Yes. So I qualified as a medical practitioner, gaining my Bachelor of Medicine and Bachelor of Surgery in 1995 from the University of Nottingham. I have also got a Bachelor of Medical Sciences and Master of Medical Sciences degree in addition to that, and my membership exams, membership of the Royal College of Psychiatrists, was obtained in 1995. Sorry, that's incorrect. In 1999. I do apologise. And I am currently a consultant psychiatrist. My role as a consultant commenced in 2004, and I was initially a community consultant in the north part of Nottinghamshire area, covering Newark and Sherwood, working with the assertive outreach team, the early intervention in psychosis team, and also I had quite a lot of patients with complex psychosis at the time. And in 2018, I left that role and moved to the city of Nottingham to work with the local mental health team covering the south part of that city. And again, that was working with the early intervention service and the local mental health service, looking after patients with psychosis.
So how many years' experience had you had looking after patients with psychosis at the time of dealing with VC?
As a consultant,
yes.
I will have had just under 23 years. And prior to that, as a higher specialist trainee, I was an academic trainee undertaking both research and teaching in psychosis, as well as doing clinical work.
You mentioned Gary Carter. He gave evidence the other day. Did you hear his evidence?
I heard most of his evidence.
He made reference to being at a meeting with yourself, Diane Hull and Dr. Thangavelu, and him saying something to the effect of, do you think we missed something? Could we have prevented this? And his evidence was all of them said, no way we could have predicted or prevented this. First of all, do you remember that conversation or something similar with him?
Not at all.
So it's not something whether you could have prevented this or predicted this that was discussed amongst yourselves, because it wouldn't be unreasonable to do so after the events of 2023, June 2023.
As a team, we were told very clearly after the incident that we should not be talking to any member of the team whatsoever, both within the service and out of the service, and I stuck to that very much. That was something that was being told to every single person that was involved.
Who did that message come from and when?
I'm trying to remember now. I think the message originally came from, I think it was the clinical lead at the time.
Who's that?
I'm pretty sure it was Sharon Heath that came into the office and said, we should not be discussing this case, not even amongst each other.
And that was in June, you say, straight after the attacks, or later than that? Because
I think that was a lot later. I can't remember exactly who said that at the beginning.
Because if you lived in Nottingham, the attacks themselves were so prevalent, weren't they, on the news and information? It would be perfectly natural, wouldn't it, amongst yourselves, before getting such a message, to have a conversation about it and say, this is one of our patients. Have a look, think about what had happened. Normal reaction, I'm suggesting.
It is normal reaction, and
so did you do it?
I remember at the time, I remember at the time thinking how difficult it was that we had been all told that we could not talk to anybody about the incident whatsoever, that we had to keep it all within ourselves. It was incredibly hard.
And you were interviewed, weren't you, by a number of reports, investigations, reviews, so
That's
you're all
right.
going along. So is your evidence you'd go along not having discussed it with others and give your own evidence? Or
That's right.
Was there nobody that you discussed it with?
There was nobody.
In terms of whether it could have been predicted or prevented, what would your answer be to that? What is your answer to that?
It's a difficult question to answer, but what I will say is that knowing a little bit around risk assessment, and I think particularly risk assessments for rare events like homicide in psychosis, we know that clinical judgment, risk assessment tools that are currently out there have really quite low predictive validity, and that predicting violence, particularly homicide, which is a rare event, is really hard at an individual level. And that's in the literature. That's something that I have read about. I've been to conferences, and we know that.
Risk assessment tools by themselves may be limited in assessing risk, but clinical judgment in combination with them can be very effective in assessing risk.
They can be effective in assessing risk across a large group of individual, sort of group data. But what is very, very difficult is assessing individual risk. And what I can say is, if I look at my caseload, there are individuals who, on paper, in terms of both clinical judgment and risk factors, have got significantly more risks than VC and have not gone on to commit homicide.
What is your caseload now?
How
many people on your caseload now?
Now, I would say just over 100.
And how many at the time of dealing with VC?
Just less than 150.
Mm-hmm. And we know you met him once, didn't you, in a consultation?
I only had the opportunity, unfortunately, to meet him once.
Well, we'll go through the notes in due course. So you meet him once, and you're relying very much on reading the notes of others, aren't you, in between our multidisciplinary team meetings?
That's correct. Reading the notes, multidisciplinary team meetings, discussions with his care coordinator, and supervision with Dr. Burry.
And there are no notes of those multidisciplinary team meetings. Why was that?
When I first started in Nottingham City team, I asked that question to the team manager, and the response that I got, I was actually surprised because the team that I had come from, MDT notes were made and minuted. And the response that I got back was that it's generally the responsibility of the care coordinators to jot down the actions of any discussions, that we don't have any admin support. Unfortunately, that's just a resource that isn't available, and that essentially this is normal and usual within the, across all of the LMHTs, the local mental health teams.
And did you suggest it shouldn't be that way?
Yes, I did. I said that, I thought it was really important that we should be recording MDT minutes, but I was told that the resource was not available.
Who told you that?
We do not have admin support.
Who did you raise that with? And
I think that was the team leader at the time when I first started with the LMHT.
A clinical team leader?
Yes.
So is that an admin position or
a managerial position?
A managerial, but were they somebody also skilled in the clinical work?
Yes.
Did they agree with you?
They didn't agree or disagree. They just said that was how it was.
Mm-hmm. But if you thought that was wrong and not in patients' interests and might not lead to actions being followed or continuity of care, didn't you want to push that further? Because it does seem astonishing, frankly, that we can't see the contents of key discussions relating to a patient.
I became aware, sort of at my consultant peer group meetings, that very few teams had that administrative support. There seemed to be only one team, and that was the early intervention team in the north, that had admin support, and that was for other reasons. It had been especially put in. So I could see that resource issues were really tight.
Is there admin support now for that?
Yes, there is. And as soon as this incident occurred, admin support was put in place immediately after that.
Why does it take an event like this to bring that focus? Because if those resources are there now, they were there before, presumably.
I can't answer that question.
But were you, as somebody who looks at risk, able to point out at an earlier stage why it's important to make people accountable for actions and in discussions? It's important, isn't it? So people know what their responsibility is going forward and they can't shake it off.
Sure.
Can I ask you to look, first of all, at documents that you will not have seen at the time relating to VC? And
of
if we
course.
can have INQY 603, this is a complaint that VC brought to the Investigatory Powers Tribunal, which is concerned and deals with complaints about the conduct of the intelligence service and whether there's been any infringement in his case. He was arguing for human rights. Have you seen this document? It was sent with a number of documents, so you may not have looked at it properly, but we can go, please, to page 2. And we see paragraph 6, if we can enlarge that. He complained organisations had carried out continuous intrusive surveillance and harassment and recorded information about all aspects of his life, said to have taken place primarily in Nottingham. Paragraph 9. The conduct began around September 2019 at the accommodation on Salisbury Street. Then it continued at Brook Court. So these are places where he's living or was living. From 2021 onwards, surveillance again at the accommodation. So describing being surveyed at his accommodation. And if we go to page 3, please. Paragraph 12, the bit in italics. The experience consists in part of a constant hostile communication with no intermissions with the complainant whenever he's awake that has lasted for the following 2 years. In conjunction with this, all aspects of the complainant's life were recorded, telecommunications, personal electronic devices and email accounts were accessed and monitored. And then paragraph 14 at the bottom. He linked the complaint of his conduct to mental health and criminality by saying the following. Throughout this period, the complainant was repeatedly told via this communication that the personal information acquired was being passed to local authorities and even members of the public to entice him to harass them and be detained. To ensure that the complainant had little recourse to substantiate his claims and seek redress, the system curated an experience that could plausibly be dismissed as a sudden mental illness. The objective of the activity, as far as the complainant can ascertain, is to harass and misinform him so as to drain him mentally, to coerce him to commit criminal activities that retroactively justify the illegal surveillance that the agencies committed. Complainant asserts the local police department is aware and involved in the illegal activity, and as such that avenue for resolution is non-viable. This was May 22 that he sent it, at a time he was a community patient under your care. It wasn't sent to you by the Investigatory Powers Tribunal. Would it have been helpful to see this document?
Yes, it would, yes.
Why is that?
I think one of the things that I've realised in sort of watching all the inquiry hearings is that each organisation seemed to have small pieces of a jigsaw puzzle, and none of us really had the full picture at all. And so much information is now being revealed that us as a community team would have absolutely no idea existed. And I think it's so important that when we make judgments, when we, make really important decisions, that we should have all of that information available. So yes, every piece of information is another piece of that bigger picture. So I think it is important.
And we know that he'd, I don't take you to them all, written many times about communication requiring technology, a system communicating in his mind. But the significance of what's on the screen, if I can take you to it again in the italics at the top, so as to drain him mentally, to coerce him to commit criminal activities. Would you have picked that up as high risk? Can you see at the top? It's actually the second paragraph.
Oh, sorry, the second paragraph.
Yeah, it's moved down, sorry. So, misinform him so as to drain him mentally, to coerce him to commit criminal activities. So he's describing that's the effect.
Okay. Yes, that
Would you have picked that up? I mean, I'm drawing it to your attention. Tell us if you wouldn't, but that's what is being stated. Would you have read that, and what would you think about that?
He's essentially saying that there are these systems in place that are forcing him to commit a criminal activity or criminal activities. He doesn't specify what that is, but he's suggesting that there's a process in place that is somehow having some kind of control over him. So yes, that is concerning.
And when we go to the notes, as early as May 2020 is when he is going into properties, bashing doors down, causing a woman to jump out of a first floor window. That's what he's doing, committing criminal activities. You know that.
And that was very much in response to auditory hallucinations, I understand, rather than some sort of mental coercion, as he describes here.
Mm-hmm, mm-hmm. Is there a difference if the activity is the same, whether it's an auditory hallucination from the victim's perspective or a coercion through mind control? It's the fact, it's the impact, isn't it, of whatever it is?
But it's also something about intent, isn't it? So in the incidents where he kicked down a door, my understanding, having read the notes in a lot of detail, was that he did not actually have any intent to harm anyone. He was responding to auditory hallucinations. He could hear his mother screaming on the other side of the door, and he wanted to go and help. So there was no actual violent intent there. There was no intent to harm anyone. The kicking of the door was an action that needed to take place so that he could help someone on the other side. And the unintended consequence, the devastating unintended consequence, was that a student jumped out of a window, but that wasn't what VC had intended to do.
In terms of risk and risk assessment, whatever his intentions were are of no significance to the person who's jumped out of the window, are they? It's the fact unintended consequences are the same risk to the victim, devastating risk.
To the victim,
Yeah.
yes.
Well, that's important, isn't it, in assessing risk to others? What your motivation is neither here nor there for those who are impacted. Might be relevant to you as the psychiatrist looking at your patient, but also relevant to you is the risk to others and members of the public, isn't it? And whether he was going in with a deluded but laudable motive as opposed to a deluded but criminal motive expressly intending harm is neither here nor there in terms of assessing risk. Do you agree?
But there is a difference, isn't there, between, going in with a laudable motive and actually going in to commit a crime. And I think you asked me what the difference was between this and the previous incident, so I was just trying to explain that to you.
This suggests no laudable motive at all, doesn't it?
No, that's right.
So this, you would say, is even more serious in terms of risk because there's no suggestion it's to help anyone else. It's a pure criminal endeavour.
That's right.
That can come down, please. Can we have a look, please, at 168, the medical notes, page 21. This is one of many medical records, but I just want to see if you were able to ascertain from this one the extent of the messages that Dr. Cedar was purporting to encapsulate. So page 21. Take your time, please, to read how Dr. Cedar summarises evidence of texts. In effect, he says in that fourth paragraph, telling my thoughts to someone else, he said that people would not mock him in person and made some remark to wanting to hurt these people he was hearing. So the context, unless you're not already aware, is Dr. Cedar's received a document from VC's brother and he's purporting to summarise the messaging that's contained within it here. What would you assess reading this in terms of the risk of the tests or what they mean, just looking at the document there?
In terms of risk to
others?
To others.
Yeah, what would that tell you, if anything, about VC? So assuming you're always interested in your patient's thought processes and what's happening in their mind, you don't have the benefit of physicians to be able to immediately corroborate it. So this is perhaps the best you can get from the person. What are you taking from this summary about risk to others?
It sounds as though he wanted to hurt the people that were talking about him, that were making the derogatory comments, but it doesn't specifically identify who these people are or a person in reality. These are individuals who exist within his perception. So, yes, I think there is some risk. But if you actually look at risk assessment and the literature on risk assessment, risk becomes really significant when you have clear, identified individuals who you either know or is known to the patient, who they can identify, that's when risk becomes significant. This is a little bit more quasi as such.
Bit more generic. So
absolutely.
Fixation or stalking, they're high-risk behaviours, aren't they?
Yes.
So if you're fixed on a particular person or following a person, that's the kind of thing you would be concerned about for that person.
Absolutely. If we knew that there were specific individuals who were being stalked or targeted, then yes, I would be a lot more concerned.
There's a theme as we go through the years of it being neighbours, people he's living with, that he is targeting. Did you pick that up at the time?
No, not really. I don't think we had any of that information. So that you know, I was sent the bundle. I read quite a lot of the witness statements from the neighbours and students, but that information was not made available to us as a clinical team.
Can we have a look, please, at NGPF 0002527? We've identified from Dr. Sedat's note the remark wanting to hurt these people, but I just want to ask you about these remarks and whether they would have heightened any concern about risk. Page 14, please. And we see at 1702, VC making reference, because I think that they are watching. I know that I can break their heads with my hands. It's a particularly graphic phrase. Would that concern you, that description?
It sounds violent, so yes, again, if we start to add together all of the little bits and statements and get a sense of a bigger picture, then yes, you know,
Page 17.
It's more concerning.
Page 17, please, 1452 and 1454. That previous night I felt immense anguish, paranoia, anger, hatred, couldn't sleep, darkest thoughts could imagine, wanted to hurt, ... permanently. What about that?
It's more of the same, isn't it?
And page 18, please. 1519. Why do I feel like this now? No, I didn't work myself into this state of mind. I was thinking about red rum not 120 minutes ago. Would you know what red rum suggests?
Yes.
What does that suggest to you?
Murder backwards.
So if you saw that text, what do you think about that?
Again, it's another piece of information that adds to all the others in terms of informing risk.
And do you think the summary I took you to earlier adequately conveyed those messages, the risk element of those messages?
No.
Dr. Sedat, of course, uploading all of these documents to Rio, no doubt if he'd wanted to do that, it's quite a difficult task. Is it a time-consuming task or not?
It's usually the medical secretaries that do the uploading.
So you can ask a medical secretary to upload something like that?
Yes.
If you were given something like that from a patient's family member who wanted to assist and were quite happy for you to use it as you saw fit in terms of sharing the information, what would you do with it?
It's very difficult for me to comment on that. I don't know the circumstances of the situation at the time, what Dr. Sedat had been told by family, if they were worried or concerned that releasing that information might have impacts for them. It's not a question I could answer without being actually in that situation myself.
Well, even if they were, either way, you still have an obligation, don't you, to share information relevant to risk. If you considered these were relevant and you identified someone saying, I was thinking about murder, not 120 minutes ago, would you share that information, whether it's actually uploading the whole document or making a more vivid summary in the notes?
Because I understood the meaning of red rum as being murder, yes, I probably would have, but I'm not sure that everyone would necessarily understand. You would have to have watched the film, The Shining, or seen it in some other some other meme or context, whereas if you hadn't, it could mean anything really.
But your evidence is, despite the fact you didn't have admin support for multidisciplinary team meetings, there would be support for a task like that if a doctor wanted assistance.
There would be.
As a consultant in
Yes.
having material made available for the rest of the team. And it's perfectly feasible, isn't it, that some people, if they can't read all the notes, might choose to just use a control function and search for what you've said, for example, as the consultant. It's possible, isn't it? If someone thinks, I can't read everything, I'll just see what the consultant thinks, or the consultant psychiatrist.
It is possible to do that, yes.
And probably quite useful for trainees and others to see what you do think on
Yes.
occasion, yes?
That's right.
So you do say you have the right support in the event you want to do that. Thank you. That can go down. And can we have, please, WITN 04280001? And this is a statement from a woman who lived in the same premises as VC between 2014 to 2015. I think we've sent you this as well, have we, Dr. Lloyd? Have you seen this statement? If we go, please, to page 2. Her impression: he was quiet and friendly, did not appear to want to socialise with other people living in the house, sometimes tried to start conversations, usually met with one-word answers, and so he'd often leave the conversation as soon as possible. Paragraph 5. If you read that, she refers to frequently waking up to the sound of someone in the kitchen, which turned out to be him at night. I remember wondering how he was able to sleep if he was often so up during the night and during the day. On other occasions, during the early hours of the morning, I heard repetitive noises, and what I describe as screaming coming from his room. A friend who was staying with me also heard these noises. And then if we go to paragraph 8, page 3. Incident when food had gone missing. Her housemate asked everyone about it. When she asked VC, raised his voice, asked why she was accusing him, which she found intimidating, walked away, and the issue was not discussed further. And then we see, please, paragraph 14, page 4. Paragraph 14, please. It's just the one below. I gave them a factual account of my time living in shared accommodation with VC. I described behaviours I'd observed, including unusual patterns of activity during the night, loud noises and interactions with housemates. So she was concerned about his mental health then, when she saw he was in the news, and had concerns back to 2014 to 2015. Were you aware of any earlier concerns about his mental health?
No.
Would that have been helpful in assessing him at the time that you did?
It would have been helpful, I think, mainly because it would have given me a much better idea of the sort of natural history of his condition. If there had been potential signs of unusual behaviour and psychosis as early as 2015, it puts a very different slant on the diagnosis.
Can that come down, please? And can we go to the documents now, 168 file, starting page 11. And Dr. Lloyd, I'm going to begin in 2020. We know he's had a mental health act assessment on the 24th of May, and this is a ward round on the 28th of May with Dr. Sedat and VC's mother present during on the phone. And we see under feedback ward round discussion, 2 paragraphs down, VC has been speaking to his brother for some time, saying he's been hearing voices since January 2020. So, in terms of the duration and nature of VC's illness, whilst we was saying anything about 2014 to 2015. It was a matter of months, wasn't it, right from the off, that Dr. Cedar was alerted to the fact that he's been hearing voices. Sorry, you nod. It doesn't pick up a nod, the transcript.
Yes, sorry,
see
yes.
that?
I'm just reading. I do apologise.
No, take your time. It needs to go further up so you can read it. VC has been speaking to his brother under family carers' involvement.
Yes, I can see that, yes.
And further down, a few lines in the same paragraph, if it can be scrolled further up, please, again, just a little bit. Dr. Cedar explained the real test for VC is when he's back in the community where he'll be followed up by a community team. Dr. Cedar says that based on what Mrs. Callacane has said, it would appear VC may be suffering from some sort of mental illness. However, only time will tell. His mother offers to send a journal to Dr. Cedar. When you read the notes, I know you read the notes, you tell us, did you spot that a journal had been sent or was available that might assist you? Can you see it?
Yes, I can, yeah. I can't remember specifically because it was some time ago.
Is it the sort of thing you'd ask for if you'd not noticed it?
Yes, potentially.
Because a journal's straight from the horse's mouth, isn't it? What they're thinking, feeling.
Yes.
And not expecting you as the clinician to be reading it later on. Likely to give you some insight.
Yes, it would be helpful.
Did you ever have a conversation with Dr. Cedar in detail about VC?
No, I didn't.
Did you have any conversation with him?
Not about VC.
Seen emails, which we'll go through later between you and him, but no conversation?
No actual conversations with Dr. Cedar about VC, no.
Wouldn't that have been beneficial, particularly when we look at what information he had even at this date?
When VC was first taken on by our team, shortly after this second admission, it was my higher specialist trainee, Dr. Bill Al-Burry, who had VC on his caseload and was doing the initial assessment and the diagnosis. And so, in actual fact, it was Dr. Burry that had the sort of more of the lead medical role and responsibility at that stage.
He might have been more reluctant about phoning another consultant, though, mightn't he, than you could have been as a consultant?
Possibly.
Just to say, is there anything I need to know about this patient? What was your experience of him?
Yes, no, I can appreciate that, but at the end of the day, we have really clear systems in place in terms of ward liaison, and it's our care coordinators that have that really important role of liaising with the wards when we have patients who are inpatients.
I'm sure Claudia Birtles will liaise with the ward and attend ward reviews, etc., but she's not going to phone Dr. Cedar. And I'm really asking why two consultants at your respective levels of experience, where we know we speak to others at the same levels of experience in a different way, a more effective way, in terms of having to explain our reasoning and having shared experience of many, many cases over years, wouldn't that have been wise, prudent, and indeed should have happened at some point in the duration of VC's time in the community?
Yes, I agree, it would have been helpful, yes.
Does that mean you agree you should have done it?
I
Phoned
think
him?
Ideally, if there had been time, I would have done that, but there are so many patients who are in a similar position coming into the EIP team from inpatient wards, and we have really clear processes in place which involve the care coordinators doing that liaison work. Mainly because as the consultant, there often isn't time to do everything as much as I'd like to. And I've already made it very clear in my statement that I had 1.5 days allocated to the EIP team. That's 12 hours per week.
Did you ever say, I can't do justice to these cases, you need to get someone else in? can't look at the detail, can't make calls to find out the information I need. Did you raise that with anyone?
Absolutely.
Who did you raise that with?
It's been raised over and over again to clinical lead, clinical directors, and this happens regularly at monthly forums, and it's not just me, it's all of my colleagues.
So at the time, this is 2020, 2021, would you have written emails about this kind of thing?
It wouldn't necessarily be emails, but if you look through the minutes of consultant forum meetings, you'll see that all of my colleagues are constantly raising concerns about the time that we have, the allocated caseloads that we have, what we're expected to do. It's a continuous and repeated issue which we bring up pretty much in every single meeting. And we're all in the same boat. It's not just me on my own. You know, some of my colleagues have got in excess of 300 people on their caseloads.
And in terms of reading these notes, we're going to go through them in some detail. Did you read them at the time?
Yes.
So it's fair for me to ask you about them because you've read them.
Absolutely.
So in terms of the journal, you haven't picked that journal up, but here we see VC in the next paragraph, MDT discussion, was asking what Dr. Ludvigsen asked him what he was thinking about, and he said capital punishment, didn't say what the solution was, and her evidence to the inquiry was that was concerning, it was worrying. Were you worried when you saw that?
I don't believe I was particularly worried by that.
Did it raise any questions in your mind? In what context is he thinking about it?
I can't remember.
It sounds like it
This is
didn't.
such a long time ago. I honestly can't remember, but I do recall reading the notes and particularly the medical entries.
Well, if we go to page 12, this is a continuation of this entry at the very top. Dr. Sedat is explaining to VC the most likely cause of psychotic breakdown is sleep deprivation and stress. VC explained he'd want to seek a period of being medication-free, that should be, so that he could better understand where he is. And so we see at the bottom under MDT plan, a bit further down from where we've cut off at the moment, please. MDT plan, we see stop regular medication. So Dr. Sedat agrees to a medication-free period, but we see from the ward review on the 2nd of June, page 17 in the notes, page 17 under patient comments, thinks people have been following him, watching him, probably since last October. And we see at this stage, he says, believes it's a matter of control. Under patient comments, never wants to experience anything similar again or cause distress to others. And the effect of it is, if we go to page 28, the 9th of June, VC is back on medication and he's disappointed about that. So if we go to the 9th of June, page 28, under patient comments, please. We see VC is disappointed he's going to have to be on the ward for longer. He's disappointed he'll need to take medication. So very early on, he doesn't want to see that he is ill and he's disappointed to be taking medication, isn't he?
Yes.
He denies feeling depressed about his illness. He hadn't thought about hurting himself or others. But he appears at this early point, 5 lines down, he believes it has been helping him, the aripiprazole. He believes it's been helping him. The inquiry's received evidence that the earlier the treatment is provided, the better for outcome.
That's correct.
And at this stage, this admission was really important, wasn't it, in terms of offering psychotherapies, understanding and communicating with him?
Yes.
And at this stage, he is accepting it may be helpful to him and appears at least open to the idea in that consultation. That's not the picture we see as we move through time, is it? It's a very different picture where that initial resistance to medication comes back fully on nearly every occasion.
That's correct.
And just so we can be clear, there's no question that it was well understood in the community team that he wasn't taking medication and he was non-concordant.
Yes, there were periods where we absolutely believed that he wasn't taking medication, but then there were other periods where we thought he was. It fluctuated.
Mm-hmm. But the illness was going to fluctuate too. Even if he took some medication, it was never going to keep the illness under control, was it? He needed regular medication, regular antipsychotic medication.
Yes.
So knowing that that phrase, non-concordant some of the time, and sort of dancing on the head of a pin whether he took it one week or the other week, it wasn't going to help, was it? He had to have a proper treatment regime to control it.
That's correct.
And it does appear, indeed, when we go through different entries, there's an over-elaborate consideration about whether he has taken it on one occasion, spit it out on another occasion, why he's got 14, a strip of 14 aripiprazole as opposed to 28, etc., etc. But in the end, it amounted to the same effects. It was well known he wasn't taking his medication as required.
So during the first year that he was under the service, under the early intervention service, and he was seeing Dr. Burry and Claudia Birtles, my understanding was that he generally was taking his medication and that there might be, I think from the feedback that I got in MDTs and from supervision, that he may have missed just 1 or 2 doses very occasionally. So I certainly did not have the information that a lot of medication was being missed.
You knew that he'd stopped taking medication after his first admission, requiring the second
Yes, I knew
admission
about
less than a
that.
month. And he
Yes.
admitted that. He admitted it during his second
Yes,
admission.
so I knew about that.
Yeah. And he's discharged from the second admission, 31st of July 2020. He told Professor Backward he'd never had any medication, or he stopped medication by October 2020.
And I didn't know that.
But by knowing that the rapid readmission was required, didn't that tell you all that you needed to know about likelihood of not taking further medication? He doesn't take it after the first admission, goes back on the second admission.
Yes.
So your starting point should have been he's not taking medication. In other words, he needed to actively demonstrate he was. Seeing him take that medication, whether it was a depot or swallowing a tablet, seeing him take medication was essential, not just to rely on what he said, given he hadn't done it before, even when he appeared to recognise some benefit from the notes in 2020.
With oral medication, it's just not possible. You know, the community team would have been seeing him weekly at most, or fortnightly, and it would be for a brief period. They would get a snapshot, but what we didn't have was the ability to see him every day and watch him take his medication, which is something that, for example, the crisis team would have the resource to do. So, you know, whilst in an ideal world, yes, it would be good to see him take his medication, but it just wouldn't be possible.
Did you ever question then whether he was suitable for referral to the EIP team at all? Given that after the second admission, taking his medication was key, and you say you don't have the capacity to test if somebody actually is or to observe it, that he should have been stayed with the crisis team. There's not an assertive outreach team, we know, but that kind of monitoring was required, that you were not fit for purpose for those purposes.
The crisis team only sees people, individuals, for a very short time-limited period whilst they are admission vulnerable or in crisis, when they've got active symptoms and risk. That is very much their criteria. And so, again, it would not be a long-term option for them to continue to see VC for however many years.
And during
under the
that
service.
Mental Health Act assessment in September 2021, Amy Staples, making a note on the day of the assessment, recorded that there was 7 months of medication that was found in his premises.
That's right.
Medication that had not been taken, months of it. So you certainly knew at the end or at the beginning of that admission that this was someone who was not taking medication to any effect at all. Is that fair?
Yes, I think myself and Claudia Birtles had a long conversation about that, and it really was at that point where we felt he ought to be on a depot and a CTO.
So what did you do to secure that? We know Claudia Birtles spoke at one Teams meet when he was at the Signet in the third admission, but you don't speak to anyone. You don't speak to a consultant. You don't attend any ward review when he's an inpatient anywhere. Why not?
It's just not possible because my 1.5 days does not allow me to attend ward reviews. We just wouldn't have. My timetable just would not give me that sort of flexibility. The ward reviews can take place at very different times, and it's very unlikely to correspond to the times that I actually work within EIP and essentially, as I've explained several times before, it's for that reason that the care coordinator has this role of liaison, and they are expected to work flexibly and be able to attend ward rounds. I wouldn't be able to do that. It is just not possible within my job plan.
Could you ask a medical secretary to communicate that message that you as a community consultant thought he needed to be on a depot and it wasn't possible for the EIP team to ensure that he was compliant or concordant with medication?
I actually think Claudia Birtles, as a clinician, is in a much better position to be communicating that message rather than it coming from a member of admin staff.
To communicate the message from you, I mean, if an admin staff wrote the letter or email from you, you're a consultant psychiatrist, that presumably carries weight. You've got immense experience. If you had formed the view, as you said you had, this man needs a depot, your service is not able to monitor him for non-concordance or compliance, why not make that clear to inpatient teams? We cannot do this.
I believe that's what Claudia did. I think she did make it clear that it was our wish. It was our strong wish that, and that was coming from me as the consultant working with the team, that we wanted this man on a depot. That's my understanding, and that was the conversation that we'd had prior to her contacting the ward. And I think she also mentioned it in a ward round. She also had a conversation with VC, asking if he would be prepared to have a depot. And I think at that point he said it's something he would consider. But it
Do you
would depend
think
on
his
the side
views
effects.
should have been determinative one way or the other, given the illness and his lack of understanding in respect of his illness?
I don't know what his capacity was at that time.
Why don't you know? You were responsible in the community for him. Did you ever think a capacity assessment as to whether he understood treatment and could weigh the benefits of treatment was beneficial?
In the community, yes, but I was never able to actually see him afterwards. So once VC was discharged at the end of October 2021, there were 5 consecutive appointments that were not attended by him. One of them was a home visit. I couldn't see him to do that capacity assessment. Had I seen him, yes, of course, that's something that I would have done. But and also it would have been during that time where I would have personally had a conversation with him about starting a depot. But that again didn't happen for the same reason, that he actively avoided every one of my appointments.
Can we have a look at the discharge summary, please, at NHFT 40223? Going back to 2020, June 2020. And if we look, please, page 2, the bottom paragraph of page 2 and the top paragraph of page 3. The discharge makes it clear. See the bottom line at the top. It's unclear whether this forms part of a greater illness or it's isolated, and his follow-up in the community will be crucial in this regard. Top of the next paragraph. VC was initially started on olanzapine by the crisis team, which he continued with in hospital. Olanzapine was stopped in order to allow us to assess his presentation without medication. When it became clear he was displaying psychotic symptoms, aripiprazole was then started. So this is the discharge into the community, isn't it? And it says in terms, again, unclear greater illness and follow-up crucial. What's your understanding of the role your service was going to have in the follow-up?
The early intervention in psychosis team is a service that's very much been set up to work with patients that have had a first episode in psychosis following clear, nice guidelines. And so, as part of our follow-up, we try to ensure that those nice recommended treatments are offered to patients, that they are followed up weekly if necessary, which is the most sort of intense follow-up that we can offer. But once somebody is perhaps showing a bit more stability, that can be reduced down to fortnightly. We do it based on clinical judgment, stability, symptom profile, how recovered they are. So
but you don't assess him. You didn't get the opportunity to assess him for the purposes of whether he would be catered for in the IOP team. Is that not how it works? You'll just accept the discharge?
Assess him on the ward.
Yeah, or assess him before you say the EIP team can take over this role of follow-up in the community for this particular patient.
We have a criteria of who we would take and who we wouldn't take, and VC would have very clearly met that criteria, having had a first episode psychosis. He didn't have any of the exclusion criteria that would have meant that we wouldn't take him, for example, a substance misuse-induced psychosis, clearly caused by intoxication or a substance, or an organic cause. So there are a whole series of
Can a one-off use of substance, sorry to cut you across there, but can a one-off use of a substance precipitate a psychotic episode?
It can, yes. It can.
Because VC describes a very dramatic experience and we know he was taken to A&E about it, with shaking of his body, tremors, feeling his mind was taken over. What's your view about that? Could that be precipitated by substance misuse?
That particular episode that he had, where he was shaking, I suppose substance misuse and taking of a substance can have very individual effects. So, yes, it's possible that he had a very severe reaction to the substance that he'd taken. I believe it was cannabis, wasn't it?
There's no evidence of whether he did or didn't take a substance. So
okay.
I'm not suggesting you do. I'm saying, is it possible, as far as you're concerned, does it require repeated use of substances, or can a single episode, if it has a dramatic effect, do that?
A single episode could, but it's more unusual. It's more unusual to result in psychosis. Again, what we know from the evidence base is that it's individuals who start early and have a chronic and repeated use of substance that are
more typically represented.
Absolutely.
Can we go, please, up to 168, page 54? So this is Claudia Birtles. And we see at the top of page 54, this is her meeting, June 2020, and straight from the off, Ms Birtles having to address medication, and she said and gave evidence, VC told her he had a couple of doses left, didn't appear clear how he's going to get, to ensure he gets a further supply, and she said in evidence patients are usually concerned to know how they're going to get the medication, and right from the off this wasn't a promising beginning, was it? And if we go down on the same sheet, 3rd of July, VC stated his no medication remaining, does not appear to have taken steps to contact his GP about this. So straight from the off, you say you're not the most equipped because you can't go every day, people from the EIP, or watch medication being taken. But this is the issue, isn't it? And again, we see on the 9th of July, page 55, she's having to ask him again. VC confirmed he'd received his medication, everything was okay. And then on the 11th of July, we see there's a phone call. Mr. Jackson takes it into the EIP team, setting out that VC's mother was concerned his mental state may be deteriorating, his conversation wasn't making much sense, and she thinks he may not be taking his medication as prescribed. So this cycle continues, doesn't it? And if we go over the page 56 in the notes, the 14th of July, if you have the whole of the box of the 14th of July, another police incident. You, of course, were due to see him on the 14th of July, weren't you? But you didn't.
That's correct.
And he, in fact, is going into residence of a flat nearby, banging on the door, and he's actually restrained by a number of residents. So his mother's raised concern about not taking the medication. He's deflecting Claudia Birtles, and this episode arises. When you saw this combination of events, were you concerned about him not taking medication and the impact again on his behaviour?
Yes, it was. It was concerning that, very early on, he had deteriorated. I mean, there was essentially a 2-week period between his last admission and this one, just over 2 weeks, and he's back in again. So yes, that's concerning. I think sometimes, though, in the very early stages of a psychotic disorder, particularly when an individual perhaps hasn't really accepted fully that they've got a condition which is going to be relatively enduring, they may feel, once they're a little bit better, that they may try to just see, well, what is it like to come off medication? It's not unusual, just to sort of test things out. And I wondered if that's what was happening here, that he felt better, he hadn't perhaps appreciated the importance of taking his medication.
Well, he should have done, because he did that when he was an inpatient, didn't he, with Dr. Cedar. Dr. Cedar permitted that and said, see how you are for a few days, and then he was psychotic and went back on the medication. So to pick that up, he'd already had the benefit of that experience, if indeed he was capable of, had the insight to learn from it. So asking for it again was very worrying, wasn't it? And if we go to 58, page 58, we see at paragraph 4, clear from today, assessment, he decided to stop taking his medication 2 weeks after his discharge from hospital. So this is the second admission confirming what had happened since the first admission.
That's right. So this is the essentially that period of 2 weeks where he's out, but then he's in again. And in actual fact, for the majority of that 2 weeks, he is under the crisis team, and they are monitoring him closely almost every day, and
it still happens.
And it still happens. So it just goes to show that even with an intense service like the crisis team, it has still happened.
So did it need an assertive outreach service? Are you saying the crisis team, your service, couldn't manage this situation because of the rotas, the lack of flexibility in terms of being there when you had to be 3 times a day if necessary to make sure you saw it happened, that you don't have the resources and capacity to respond like that?
We certainly didn't have the resources or capacity as an early intervention psychosis team. I can't really comment for the crisis team.
On the 13th of July, if we can have NHFT 0017977, page 2, you're trying to arrange that appointment that he doesn't attend on the 14th, and you send it to Ms Birtles. Hi, Claudia. I think if you can't attend, there's nobody else to sit in. We need to change it back to a telephone appointment. I can do face-to-face next time when you're present. Why was it important for you to do a face-to-face when Ms Birtles was there?
It's really important, I think, when I see a patient that I have a care coordinator who knows the patient well, that has been in contact with that patient on a regular basis, to be there to inform me of any issues, of anything that they've observed, any risks, and also be involved in the decision making. And that's how we've always worked in early intervention in psychosis, where we do joint appointments.
Do you think, as a psychiatrist, you are better able than the care coordinators to challenge and explore with a patient why they're not taking medication, for example? Because it doesn't seem, on the records at least, that he's ever really confronted about the impact and how it can't continue, in effect.
I don't know. Sometimes, you know, if a patient builds a really good rapport and trust with a clinician, it doesn't matter whether that clinician is a consultant or a nurse. It's that trust and rapport, I think, that is key.
And what's the issue about stigma, worrying about... we've seen he's got a functional illness. Dr. Cedar states that very early on in July.
Yes.
Doesn't appear in his care plan. Doesn't look like VC's told about it. We'll hear in due course if his family are. What's the issue about protecting patients from a reality if they have a functional illness?
I don't think there is an issue about protecting a patient from reality if they have a functional illness. I think what we have to remember is that psychosis is a broad umbrella term, and under psychosis comes a whole series of different specific diagnoses, one of which is paranoid schizophrenia. You may have delusional disorder, you may have schizoaffective disorder, it may be a bipolar disorder with psychosis, or depression or mania with psychosis. They are all specific diagnoses that fall under the umbrella term of psychosis. And the reason why in early intervention we don't give specific diagnoses is because we know that in the first 3 years diagnoses change a lot. A concept called diagnostic stability. The illness is going through a slow evolutionary process, and what we see right at the outset isn't necessarily what we find at the end, and that's part of the assessment. So
the illness is likely to be the same, or one that's developing, but you may not detect it earlier on. The diagnosis.
Yes, it might present in very, very different ways, so that you might, right at the beginning, think, okay, this is more of an affective picture, but later on down the line you start to realise, no, it's not. It's starting to look more like a schizophrenic picture. So that's why we keep that much more broad terminology of psychosis. Psychosis doesn't mean that it's necessarily short-term or temporary or non-functional. All it means is that we're not pinning it down to a very specific ICD-10 diagnosis.
But you do say something in your statement about why in the EIP service you're careful not to label early on.
That's another secondary reason, and I think that's something which, right from the outset of EIP services being developed, it's a very strong sort of ethos of the service that we focused very much on reducing stigma, that it's a recovery-focused service, so it was very much about instilling hope that people could get better, rather than right from the outset giving the message that, you know, this is a lifelong condition, that you know, you will never get better. One of the things that the literature found was that lack of hope, that lack of sort of recovery-based thinking could lead to high rates of suicide in young people.
Recovery-based communication can be positive, but only if it's backed with an ability to require the treatment that brings about recovery. Do you agree?
Absolutely, yes.
And what we don't see here is that part of it.
Yes, and it's not that we didn't try.
Well, we'll come to that later. It's probably a good time to stop. Thanks.
Thank you. We'll start again 2 o'clock. Thank you.
Please stand.
Yes.
Thank you. Can we have 16864, please, on the screen? Dr. Lloyd, this is 16th of July 2020, 72-hour review. And we see under patient comments, page 64, third paragraph down. Dr. Sedat observed there seems to be no insight or remorse, and the danger is this will happen again, and perhaps VC will end up killing someone. VC responds by saying it will not happen again. Did you see this in the notes?
Yes, I did.
Did you agree with it, what he said?
So when I read this in the notes, having also read in detail the events that had led up to both the first and second admissions, I felt that his comment here had to be put into context. And I understand that Dr. Sedat does go on and put it into context. What he is saying is that Valdo's behaviour, i.e. attempting to kick down the door, the unintended consequence of this was that the student jumped out of the window, and that should he do it again, it could be that she jumps out of a higher window or something else happens and he ends up killing someone, not that he has clear intent, planning, you know, any kind of premeditated wish to kill someone.
But his actions could result in killing someone.
That's right, yes.
So you agreed with that when you read it?
Absolutely.
And if we if we go please to NHFT 0000222, we see the discharge summary. It repeats what's in the note that's just coming off the screen. The diagnosis, primary diagnosis of schizophrenia. So if we go please to page 2. Primary diagnosis, paranoid schizophrenia at this time. Dr. Burry was the one who conducted further examinations, wasn't it, in respect of VC rather than yourself soon after?
That's right.
But whether he described, he thought, 2 consecutive episodes of psychosis or a psychotic disorder, but the treatment would have been the same from what you were saying before, antipsychotic medication in conjunction with psychological therapies. Is that right?
That's correct.
So I don't want us to get hung up on a diagnosis. The treatment was the same at that time.
Yes.
Psychoeducation and relapse prevention work should have been going on in the community, shouldn't it?
It should, yes.
Why wasn't it?
I'm not certain why it wasn't started immediately, but I do believe that Claudia Birtles did a good piece of psychoeducation work and relapse prevention early warning signals with VC in January 2021.
Well, I don't mind us jumping to that if you like. It's NHFT 40168, page 145. And this is the relapse prevention plan, page 145. And so VC started to complete card sorting exercises for the plan. And let's have a look at the bottom of it. If VC were to become unwell again, he'd like people not to be overly judgmental. He'd like to avoid hospital, use least restrictive practice, increase contact with care team, crisis team, speak with family on his behalf. He'd like to remain on aripiprazole. He has been on this since the start. It's hardly a relapse prevention plan, that, is it? Whatever he's been asked to do, that's simply I just want to get on with my own thing, isn't it?
This looks like an advanced statement, actually, rather than an actual relapse prevention plan. Yes, I agree. It looks as though these are VC's wishes in terms of what he would like to see in the event of a further relapse.
And they look like very rehearsed in terms of Mental Health Act language and terminology, not to be overly judgmental, least restrictive practice. Do you agree?
Yes.
Do many of your patients say, I'd like you to use the least restrictive practice?
No, they don't.
Have you ever heard that?
Not that I can recall, no.
And you've had how many patients?
Over the years, gosh, thousands.
Do many say, I don't want you to be overly judgmental?
That depends. It depends on the sort of the education and the eloquence of a patient. So yes, occasionally that has been said.
Where criminal acts have been committed, there's a requirement to be judgmental, isn't it? Even within mental health services and developing a therapeutic relationship with a patient, to recognise behaviour that falls under criminal law. Do you agree or not?
I think we would do everything in our capacity to prevent further criminal behaviour, yes. It's not something that we would endorse, no.
Can we have that down, please? In NHFT 40202, page 1, we're going back to 2020, 1st of September, the summary care plan sets out summary formulation at the beginning. Formulation doesn't actually, it's agreed, set out risk management, anything of that kind. If we go to the bottom of the page, it doesn't include the primary, the schizophrenia diagnosis. And if we go to page 3, please, we see actions listed, regular contact with care coordinator, how often VC has contact, etc., services to build therapeutic relationships, and under actions further down, ongoing monitoring of mood, mental state and behaviours, continue to explore and develop coping strategies that might prove effective. And the responsible people are named as yourself and Claudia Birtles. In terms of Claudia Birtles, we're agreed she wasn't doing detailed relapse prevention planning work with him or risk assessment management plans, was she, with you?
Sorry, could you repeat the question?
She wasn't preparing risk assessment management plans with you, and she wasn't preparing either relapse prevention plans or anything of that kind.
Not with me, no. I wasn't directly involved in VC's care at this time. I think I've mentioned before that Dr. Burry was the doctor that was working with him directly, and so my involvement was more indirect in terms of supervising him and providing expertise to the MDT.
Well, we see in the top box where it said completed psychoeducation and relapse prevention planning. Neither's happening. Dr. Burry goes and does one of the mental state examinations, and he's a trainee, isn't he? He's an ST5 or an ST6?
He was an ST5 at the time.
So he's an ST5. So he does his mental state examination in accordance with his level of skill. You aren't doing the mental state examinations at all, are you?
Not at this stage, no.
Didn't you think in this patient that would be wise that you should do one?
VC at this stage is not really different to most of the patients on our caseload. So there is nothing particularly unusual or unique about VC's presentation at this stage. Our trainees, particularly our higher trainees, have to be able to work relatively independently and autonomously. We follow clear college guidelines on these issues, and they have certain competencies that they must meet. The supervision level is indirect.
His name's not on the care plan, though, is it, Dr.
I don't
Burry?
know why it's not on the care plan.
Are they sometimes ST5s on the care plan names?
Yes.
Why is your name? You see, it's not clear what your role or responsibility was listening to you.
My
What were you
role
expected to
here
do?
is having oversight. As the community consultant working in the team, it's having oversight.
So are you responsible, for example, for the review of his antipsychotic medication or
No.
discussion around that? Who's responsible for that in the community?
Dr. Burry would be at this stage because VC is on his caseload.
Did he ever discuss his medication with you, his treatment, what he needed, whether it needed to be adjusted?
Yes, he
anything like
did in supervision sessions. Each time an adjustment was made, we did talk about that.
that? What about the elephant in the room, the one that you knew that he wasn't taking it anyway?
I didn't know that at this stage.
We discussed this morning how readily apparent, and went through a number of notes with Claudia Birtles referring to the fact he said he had 28 days when she knew it was 14 days medication and the like. He's constantly saying things that are very capable of disproof if you look a few pages before or afterwards. Are you saying when you spoke to Dr. Burry around this time you hadn't done that exercise to see?
I hadn't specifically looked through the notes at this stage, no, because Dr. Burry was essentially leading medically and was working alongside Claudia Birtles. So no, I wouldn't have looked at the notes specifically at this stage.
When did you look at the notes and assess for yourself he was not taking medication as he should?
So the only time that I knew that he hadn't was when Dr. Burry handed VC's case directly over to me, which was at the end of his placement.
When was that?
With us. That would have been 31st of July 2021. So this is all in 2020, I'm guessing. And that's when I would have had the handover. I would have gone back and read in a bit more detail about VC's presentation.
So the care plan stays the same, very little update. So in 2021 then, in accordance with this care plan, what were you doing around relapse prevention plans or monitoring mood, mental state and behaviours of VC? Because that's what it suggests you're doing, and it's the same plan later on.
So the first time VC is booked in to see me is on the 9th of August 2021. There's a clinic appointment.
But we know you don't have that. I've got all the did not attends. We can deal with that. What did you actively do? Can we just confine ourselves to that?
There was very little that I actively did because I hadn't had the opportunity.
So is it nothing? It's just nothing. You didn't see no relapse prevention plan. Just to cut through this, we've got a lot of documents to go. If we actually look at what the care plan says you are doing, is the answer didn't do any of that? Either in 2020, because you didn't expect yourself to do it, but 2021 likewise.
I didn't expect myself to be doing any of those actions at this point, and I don't know why my name is there.
And in 2021, when you'd taken over from Dr. Burry, is it the same? You didn't expect or believe you were responsible for risk assessment on a regular basis, monitoring of mood, mental state and behaviours?
Those actions, carrying out a level 2 risk assessment on a regular basis, the fortnightly monitoring of mood, mental state and behaviours and coping mechanisms are all roles that the care coordinator performs. So the formal level 2 risk assessment forms are done by the care coordinator. The fortnightly monitoring of mood, mental state and behaviours is the role of the care coordinator, and exploring and developing coping strategies is also her role. If VC had agreed to have CBTP cognitive and behavioural therapy for psychosis, then the work around developing coping strategies would have been done much more intensively by our team psychologist.
That places a lot of responsibility on the care coordinator, doesn't
That's
it?
right.
And none on yourself. There's nothing.
Absolutely, yes. And that's why they have a capped caseload of 15, or they're supposed to, because they have an extremely broad, overarching role. They are the lead clinician.
We've got the point for her role, thank you.
In this case.
Annual care programme approach, those reviews.
Yes.
Were you involved in those? We understand the initial care plans done by the care coordinator in collaboration with the patient. What about the care programme approach reviews?
So
Do you
yes, so
look at those?
the CPA, the care programme approach reviews are done annually. Mm-hmm. And I understand on this occasion, in 2021, the review was done before I took.
So you never did one of those reviews, so
No.
just so we're clear. Okay.
No, so I wasn't involved because it happened the month before. My first appointment with him was the 9th of August, which he didn't attend.
Yeah. And in terms of risk assessment, are you saying that was delegated to the care coordinator?
No,
The level of-
they carry out the formal risk assessment form, which is in Rio. But what we always do is we discuss risk in a lot of detail in the MDT.
Why aren't those meetings recorded? It's easy enough these days, just record them, press a button, or get your medical secretary to take a note. They
I've
send
already
emails
answered
for
that
you.
question.
Yeah. But it's very convenient, isn't it, to say it was discussed, because we've seen no documentation between you and Claudia Birdles about risk assessment or forms or whatever you need to complete.
I can't change that. It's something that wasn't done. It wasn't just our team. It was across the local mental health teams. I can't really say much more.
And that's because it wasn't done, was it? Risk assessment wasn't done in accordance with that care plan at all.
Risk assessment was done regularly, and there was a very clear understanding of risk by Claudia Birtles and myself, but only based on the information that was available to us.
There was risk to Claudia Birtles, wasn't there? There was a risk management discussion between you and her about her no longer being VC's carer and people going in pairs. So there was risk assessment for her. You didn't have that discussion with her?
That was not me. That was a risk assessment done by Emma Robinson with Claudia Birtles at the time, because Claudia was pregnant.
And did you know about that? Were you part of that risk assessment?
I wasn't part of that risk assessment. They're usually done between a clinician and their line manager.
So that risk assessment took place. We've seen notes of that, but there wasn't a risk assessment of VC's risk to neighbours, those around him, or in the light of the events that had happened in 2020 and 2021, was there? The risks to the public and other people.
I know that those risks are listed in the level 2 form, but I think unfortunately, the detailed risk discussions that we had, no, because they were part of an MDT discussion. They were not recorded. It does not mean that they didn't happen. And we had an understanding of the risk to the public, and I had a clear understanding of risk as I knew it, and that's something that I've documented in my witness statement.
Let's move on now to the documents. NHFT 0017810, page 2. This is Dr. Cdat emailing you. From what you said earlier, there's no conversation, you just email each other, and he lets you know that he's surprised in November 2020 VC tries to contact him. So we see at page 2, his email at the bottom, and yours at the top. 4 days later, looks like the team have been making a concerted effort to visit and follow him up. Patient's not been engaging. CPA and Gary Carter's now seen him, as you can imagine. Patients with psychosis can sometimes behave in quite erratic ways. Were you interested to know why he was looking or wanted to speak to Dr. Cdat?
Absolutely. And so as soon as I've sent this email, I make sure that VC's review is brought forward so that Dr. Burry assesses him much sooner than he otherwise would have, so that we can learn why it is that he wanted to see Dr. Cdat.
And if we look, please, at NHFT 00178110, page 1. Contrary to what you said a moment ago, Dr. Lloyd from Gary Carter, 9th of November, took 28 days of meds out. He said he had about 10 left, question mark. Needless to say, I kept the new meds and will liaise with Claudia about going out and again. So Gary Carter doesn't email often from what we've looked at, does he?
No, he doesn't.
And he's emailed you querying medication, VC's medication, what's left, what's going on against this backdrop. Did that make you ask further questions or wonder why he was doing that?
I knew that there had been a period where he hadn't engaged, and I think I must have assumed that because they hadn't been able to see him for that period, that the medication I'm not sure. I don't remember this email, but yes, I can see that he said that.
So he's worried about medication at this time. And if
he said that there's about 10 left, yes.
168, page 138, please. This is the 10th of November, Bill Albury note. And the plan, the bottom, close monitoring in the community by the care coordinator. So what did you think was required, the close monitoring?
The most that we could offer was weekly at this stage.
So in your discussions about risks and generally, did you think you needed to escalate this or get a mental health act assessment or do something to reflect that you couldn't possibly closely monitor according to...
I don't think he would have met threshold for a mental health act assessment whatsoever at this stage. There is nothing to suggest here that there is an increase in risk to either himself or others or a deterioration in his self-care. So no, he wouldn't meet threshold. And I think the other difficulty is that he's not in immediate crisis. He's come forward. He's been very open with the team. He's told us for the first time that he hasn't been completely honest with the inpatient team.
Very, very open with the team. With all you know now, let alone what you should have known then, are you actually suggesting he was being open with the team?
I think he was being more open than he had been.
Well, that's not... You asserted he was being open with the team. He wasn't, was he?
He was telling us that he's continuing to have symptoms, which is something that we didn't know.
And he wanted to be more open, arguably, with Dr. Burry or Dr. Cedar, saying what in fact had happened, that he'd been hearing voices and just said he hadn't to get out of hospital. And when he tried to do that, I think he gets a response. Couldn't it have waited till a Thursday from Dr. Burry? And Dr. Cedar phones him and says, it's not my job, it's back to you. Do you think this lack of continuity of person or care impacted here?
Possibly. I think often patients will form a strong relationship with a clinician very, very early on in their patient journey, and it looked to me that that VC had quite a lot of rapport with Dr. Cedar, because I know that this isn't the only time that he's gone and asked for Dr. Cedar. I think it happens again consequently. So he keeps going back, wanting to talk to the doctor that he'd originally formed that relationship with. So yes, I think continuity of care can certainly be an issue, and I think we know that, particularly with all of these separate teams, it is very difficult.
Can we have CQC M0016518, page 33, please? In fact, page 34. So this is the CQC report, page 34, third paragraph. Despite the evidence that VC was symptomatic on the treatment prescribed and had been admitted to hospital on multiple occasions over a short period, there was no change in the approach to treatment. NICE guidelines are clear that people with schizophrenia whose illness has not responded adequately to treatment should have their diagnosis and treatment reviewed to ensure it is an adequate dosage and for the correct duration. We know between the 2nd of Feb 2021, 13th of April 2021, he's not reviewed by a nurse or assessed by a doctor. 6 weeks, 2nd of Feb to the 15th of March, 6 weeks, he's not seen by anyone. What would you say about that?
From the 2nd of February...
And the 15th of March 2021.
That's 6 weeks.
Yeah,
Do we...
and he sees Dr. Bury on the 15th of March for a memory test. And his next face-to-face review is the 13th of April 2021, 4 weeks after the memory test.
So do we... I'm not certain why that 6 weeks he wasn't seen by anybody. The care plan would have suggested that it should have been fortnightly at that stage.
But it wasn't, was it?
No, but I don't know why.
So whose responsibility is that? If you can't do it yourself and you've delegated it to Dr. Bury, whose responsibility is it to make sure it happens in appropriate times?
Dr. Bury would only see VC as and when required, and it's usually our nursing staff, the care coordinators, who book in appointments for doctors to see patients. That's how it works in all of the early intervention teams and also in the LMHT. So I'm
Beginning
not
to wonder
sure.
what the psychiatrist does, if you don't mind me asking, Dr. Lloyd. So they're responsible for knowing when these doctors' assessments need to be conducted. They're the ones assessing for signs of psychosis, are they, as well, even though they're not doctors when they go out to these visits? They're monitoring
they do the
medication.
monitoring, yes.
Well, that's assessment, monitoring, telling you when it should happen.
Yes, they do. They book in the medical appointments. It's not something that I necessarily agreed with. I'll be perfectly honest with you. And I did email both the administrative staff and also my line manager to say that I wasn't particularly happy that appointments were being booked in for the medical staff by care coordinators as often, you know...
As was required by the sounds of it.
But
I didn't like that many.
But I got a response back saying that that's what happens, that's the usual practice. And I have copies of those emails if you need to see them.
May 2021, were you aware that VC had gone to Thames House in London? You didn't hear anything about that? Would it have been helpful to know what he was thinking about going down there and asking him about it?
I didn't know about that, no.
Did you know in July that he had assaulted one of his flatmates, who he subsequently became fixated on and tried to follow?
No.
We mentioned earlier stalking and being fixated on people. It's very troubling, isn't it, when those offences arise?
That's right.
If we can have 168157, please. This is the appointment date, 9th of August 2021, when he doesn't attend the appointment. See at the bottom of 157. Didn't attend at noon. 157, page 157, please. The penultimate box. Did not attend his clinic appointment at noon today. CPM feels he might be relapsing, so she will book for a home visit with your ST6. Why was it that you wouldn't do a rearranged appointment as the consultant?
I was aware that I only had one home visit slot, and unfortunately it was booked with another patient that needed to be seen just as urgently. However, Dr. Sasidaran Sasitha had just started, had taken over from Dr. Bury.
So she was quite new in the role, was she, for psychiatry?
But she's a ST6, so she was 6 months away from becoming a consultant herself.
Well, let's look at page 159, what she finds. So somebody, again, new to VC, meets him, and we get this report, paragraph 4. He's been doing fine. Reported he's compliant with his medications, no side effects. bottom paragraph, mental state examination, voices become faint, no longer distressed, not responding to unseen stimuli, happy to follow medical advice and is willing to continue to take medication. Impression, mental health has remained stable. No challenge or probing there of medication when he says at the top, line 3, compliant with his medications and no side effects reported. At the very least, it would require to have a look at where he keeps his medication, what he's got there, testing it out, having a conversation about that. There's no probe whatsoever, is there?
It doesn't look like she checked his medication, no.
Would you have checked? Would you have asked more about that, given the background and your CPN thought he was relapsing?
Yes, probably.
Well, probably or definitely. It's fundamental, isn't it?
Yes, I would have checked.
So somebody relatively inexperienced to you does that assessment and all looks well at the conclusion of that, and that's not the case. It wasn't well, was it?
I don't think it was, no. I can't remember specifically what the next appointment showed.
The next appointment with you, 2nd of September, 163, page 163, the bottom box. You were due to be attending with a second doctor. If we go over the page, he didn't answer the door, no response. And this was when events led to the Mental Health Act warrant and the assault on the police officer.
Right.
So things weren't well. Moving forward, at 167, please. And if we can look under scene, third paragraph, officers went to restrain him and he seriously and repeatedly assaulted the male officer particularly. Have you ever watched the body-worn video footage of this event?
No.
So what do you rely on in understanding what happened at that event?
I rely on the medical notes and the description of what's happened. I rely on any further information brought to me by the care coordinator that she may have gleaned in her dealings with VC, and usually after a mental health act assessment like this, there's a long period of inpatient assessment and there are detailed notes about somebody's mental state, risk, all available in those notes. But unfortunately in this case, he went into a private hospital and we weren't able to access those notes.
But you could see he'd seriously assaulted a police officer.
Yes.
You haven't seen it since to see that there was a degree of planning when he takes his glasses off, puts them on the windowsill,
No.
indicates he doesn't want to hurt female police officers, but he'd like the male officer to take him out of the room. And yet you commented in your statement at paragraph 255, very likely he acted in self-defence. He perceived himself to be under attack from the police and needed to fight for his life.
Yes. So the reason for that was that both Claudia Birtles and I had a conversation about this particular event, a detailed conversation. I'd also seen Dr. Ben Lomas's entry in the notes. And what we concluded from this, and certainly what Claudia said to me at the time, was that this was a man who was floridly psychotic. She had seen him, I think, just prior to this Mental Health Act assessment with Gary Carter and had felt that he was extremely unwell. He had a strong belief that there was a conspiracy against him, that a group of people comprising MI5, the police, the government and mental health services were all conspiring against him, and that we were using some kind of technology.
We've got that. So the 31st of August, that meeting.
So he was extremely frightened. And then a group of people, including the police, forced entry into his property, the very group of people that he is incredibly paranoid about. And I could see that would feel really threatening.
Dr.
very
Manzar was
provoking.
there, wasn't he? Dr. Manzar, he already knew, Dr. Lomas, Amy Staples, so mental health professionals, not just the police. And afterwards, he described it as poor judgment from himself, didn't he? But anyway, you've commented as to what you think likely happened in that moment.
I, having spoken to his care coordinator, having had a detailed discussion with her, having thought about his kind of perceived thinking, how VC might have felt, given those fixed, strong delusional beliefs, and having individuals who form part of that belief walking into his property against his will. Now, obviously, I wasn't there. I hadn't seen the video footage, so I made a comment based on the knowledge that I did have.
Might it have been better to view the best evidence before you did?
I didn't even know video footage existed.
Can we have NHFT 0018143, page 1, please? And this is an email from Claudia Birtles to you. VC on this detention is applying to a tribunal for his release. Ms. Birtles says to you, VC has a tribunal next Thursday. I'm going to suggest consideration of a depot. Hope that's okay. This was a consideration after his last admission. However, Dr. Sedak gave him the benefit of the doubt and agreed to continue with orals. Your ST6 responds, I do agree with depot, especially him having no insight. Did you see the email?
I definitely saw Claudia's email.
Mm-hmm. Did you not respond to it then?
It was sent to me, VC, yeah. I probably had a conversation with her after it, rather than actually do an email response. I'm only in the office above, and Claudia often came in and spoke to me face to face.
But you agreed with it? You agreed
Absolutely,
with the depot?
yes.
And indeed, you do a report for the tribunal. If we can have CYGN 5011, page 3. Page 3, you set out a diagnosis. Sorry, that can come down. Different person, sorry.
Oh, okay.
Don't worry. Did you read the tribunal ruling?
I don't think I ever saw the tribunal ruling.
Were you interested to read the ruling, knowing he'd made an application?
Yes.
So why didn't you read it?
I don't think I ever received the ruling at all, but I did receive verbal information back from Claudia.
What did you understand it had been? And perhaps we can have CYGN 5056, page 3. We see there, if discharged, will be very concerned about VC's own safety and that of others. He hears voices, gains access to others' properties, behaves in a way perceived as threatening to others, has been violent towards others. When he is unwell, the risks are serious. Did you agree with that?
Yes, the risks could be significant when he's unwell.
Could be not the same as when he's unwell, the risks are serious. Not could be serious, are serious.
The only time they have been serious from what I believe is the attack on the police, the 2 police officers. I've already told you about my views of him kicking the door down and what I believe the risks to have been at that time. But I think certainly on this occasion, just going to his 3rd admission, yes, the attack sounded very serious.
And if you go to page 5, please, Roman numeral 3 at the top. VC's delusions sufficiently severe and distressing so as to cause him to seriously assault a police officer and require physical restraint. Second time his illness has resulted in someone else suffering a significant injury. So that's the same as the woman jumping out of the flat. And paragraph 13, unequivocal evidence, further down the page, the risks to others when VC is unwell are high, relapse occurs rapidly and is difficult to manage. These risks eventuated very recently, and it's important they are minimised so far as is reasonable before VC is discharged into the community. You should have read that, shouldn't you?
I should have received it, yes. Yeah, and I don't know why I didn't. It may be because I wasn't involved in the particular tribunal.
And the findings are, when he is unwell, high, relapse occurs rapidly and is difficult to manage.
That may be true for the second admission, but we know now, don't we, that actually it's possibly not true for the lead up to the third, because he apparently stopped his medication in October, but I guess the tribunal would not have known that.
Say that again.
So, in October 2020, when VC apparently stopped taking his medication.
So he tells Dr. Blackwood, yeah. So much earlier on in his illness.
There's been a 9-month period leading up to September 2021 when he actually relapses. So there's a long period of him not taking medication and not relapsing immediately.
But you don't know, do you,
I don't
about
know
Sebastian, the events with Sebastian in July 2021. He assaults him. You don't know how he's following him. You don't know about when he goes to Thames House, why he's there. So what's your assumption that there's no difficulties or complications arising from his mental health at that time?
But my understanding is all of those events occur either mid or later in 2021 rather than early on. But yes, at the time I wouldn't have known that.
And it's guesswork for you, isn't it? Because you never saw him and you only had the records, which we've got in front of us.
Yeah.
So can we have a look, please? 168, page 195. This is after his discharge. We see top of the page, 195. 25th of October, Claudia Birtles, underneath note, VC wasn't sure exactly how many tablets he was discharged with, but believes it was possibly a 28-day supply, and Claudia Birtles yet to receive the discharge summary. If we go to PAGR 5029, page 3, we know from page 3 of the summary, he was discharged to his new flat with 14 days medication. So very self-evidently and immediately telling a lie about the amount of medication he had to Claudia Birtles. Did you detect that at the time?
I don't think the discharge summary was available to us at that time.
Well, it won't have been soon thereafter, will it? Soon enough if you wanted to see what he said. Did you detect that at any time?
I honestly don't remember seeing this discharge summary.
You saw what Claudia Birtles had said about the medication. Did you suggest to her, well, look, given we wanted a depot, it hasn't happened, let's move on, double-check, treble-check this medication?
My intention at this time was to try and see him and to have a very frank conversation with him about depot medication. And that was very much the plan at this stage, that there was a conversation with him where we made it really clear that we felt he needed to be on depot.
If we look at 198, please, at the bottom, 168, 198. 15th of November. He doesn't attend the appointment with you. So 168, page 198, doesn't attend his appointment at the bottom of the page. You say in your statement you didn't have any concerns about him not attending this as he'd been seen by Claudia Birtles earlier. It's not the same, is it, being seen by the care coordinator and seen by you as the psychiatrist, the consultant psychiatrist?
I think it's unfortunate that he didn't attend, but the reason that I make this comment is because the DNA policy for the Trust is really clear that if a patient doesn't attend, we need to try and assess or get some idea of the level of risk. And as part of that assessment of the level of risk, it's about whether a patient has been seen by somebody else, another clinician in the team, how they were at the time, was there any evidence of relapse, was there any evidence, signs and symptoms of psychosis. And whilst ideally I would have seen him because I wanted to have this conversation about depot, I felt at least he has been seen and there are no immediate risks to self or others highlighted.
Page 199, please, at the top, 19th of November. Claudia sees him, Claudia Birtles. 199, top box. VC said he'd missed a couple of doses of aripiprazole, later failing to collect them last week. Been taking 10 milligrams since the admission, aware he needs to take 20 milligrams. So clear not taking his medication is required, and we see, if we have the rest of the page illuminated in one box, we see, please, that 29th of November he didn't attend, 6th of December, third missed appointment with you, and medication due on the 14th of December. So you've had 3 missed appointments at this time, haven't you, in this period, when you say you want to speak to him about depot?
Yes.
And you know he's not taking the medication and you're sufficiently concerned to want to raise forcing medication through depot?
That's what I wanted to do at this stage, definitely.
So what did you do at that point when he hadn't come for 3 times?
I was starting to feel this isn't good. However, patients who are in the community, who are voluntary, cannot be compelled to attend appointments or indeed to take their medication. And that is unfortunately the position that we find ourselves in.
So you thought there was nothing you could do at that point?
We didn't have powers at this point to do a lot more until he actually met clear threshold for a mental health act assessment. They are essentially the only powers that a community team has in the community, unless a patient is on a CTO.
He wasn't taking the treatment that was necessary for his mental disorder. You knew that.
Yes.
So why not trigger a mental health act assessment
Because
for detention under Section 3 for treatment?
Because he would not meet threshold for a mental health act assessment. It is very clear, the Mental Health Act has principles of least restriction, it has codes of practice. Now, as far as VC is concerned, what we would have to show was clear evidence of deteriorating mental health and a clear risk of harm to self or others. And whilst...
You have the tribunal findings. Rapid relapse, risk to others. You had the evidence.
That is not enough evidence. That's historic evidence of things that have happened historically. The evidence that we'd need to be showing here is that there is a current risk at that time of hallucinations, delusions, or thought disorder, that there is also some kind of risk, some kind of escalation of risk to self or others, and that could be thoughts or comments around self-harm, thoughts of comments of harm to others, escalating violence. That could even be a third-person report. So, for example, if Mum had contacted us at that time and said, look, I've had numerous phone calls with him, which I know she had during this period. Celeste Callacane had said, I'm really worried. I think VC's mental health is deteriorating for these reasons. We could have taken that to the AMP because there are thresholds that need to be met, even in terms of calling a Mental Health Act assessment.
Can we look, please, at NHFT 40417, page 7? And this is the relevant policy in place at the time around not attending DNAs. We see at the top, actions to be taken by the clinical lead to understand and mitigate risks may include the following, where risks are identified. If we go down to the third bullet point, contact will be made with patient's GP on the day of the missed appointment, consideration given to an urgent home visit, making contact with known relatives, carers, neighbours, friends where appropriate, consideration to arranging a Mental Health Act assessment, police may be contacted to request a welfare visit, other services such as the crisis team or the assertive outreach team may be asked to continue trying to contact the patient out of hours. So it continues. After the 3 successive DNAs, did you trigger any of these responses?
This is not the the policy that we were using at the time. The one that we
It says
were
policy
using,
trust-wide on page 1, not that we need to turn to it, but it doesn't suggest it's not for the EIP.
No, it's not that it's not for EIP, but I think there may have been another policy that we were using at the time. I think unfortunately the policies get changed. If you look in my the one that I refer to repeatedly in my statement, that's the policy that.
Just tell me what you did. Whatever the policy said,
what we do as part
now,
of.
what did you do after 3 DNAs by him? What did you trigger
after 3 DNAs, we then take it back to the multidisciplinary team and we talk through what are the options, what can we do to engage this man at this stage.
What did you do?
Are there any options at this stage? And I think at this point we decided that we would really try to enlist the help of Celeste, with whom he had a good relationship, with whom.
So what did you do?
So there was a conversation. So Claudia spoke to Celeste and said, we really need some help here. We need to try and get VC to come to his appointment so that Dr. Lloyd can have a conversation with him. And she does that on our behalf. I think VC's response to that is that he's been extremely busy with his university work. He's had a lot of deadlines and he's really struggling.
Let's just see what his response. Let's stick to the point you were making. 168, page 201, please. And this is a note, 16th of December, 2021. And VC is very confrontational and angry throughout the call. Asked why I tried to make contact with him via his mum, went on to say under no circumstances could I have any contact with his mum as it was stressing her out, totally unnecessary. He was contactable via his own number. She went on to explain that there was a concern about lack of contact from VC. VC has missed 3 appointments with Dr. Lloyd and hadn't replied to text messages since November. VC did not agree with this and told me he was cutting this contact off completely and I was never to speak with her again. So that response to go via his mother didn't work, did it? He didn't want her having information and he didn't want to speak to Claudia either. So can we go to 168, page 202, please? 10th of January, we're into 2022 now, and another missed appointments. Didn't attend your 12 noon appointment. The 4th appointment he has missed, 1 home visit by me. He's also disengaged from his CPN, Claudia. We don't know if he's taking his medication. We'll discuss next steps at NDT. So, don't know if he's taking his medication. You know there are attendant risks. He's not engaging with Claudia or you. Can we have, please, NHFT 0018181, page 1. That's the 10th of January that did not attend for you. And on the 10th of January, Emma Robinson sends an email to Claudia Birtles. So NHFT 0018181. Page 1. Hi Claudia, please bring for discussion on Thursday. We may need to consider discharge. We know he can become unwell and has had admissions, but he's not engaging at all. I don't know what more you can do. I know we discussed looking at a different CCO, but I don't think that will change engagement with services, but happy to discuss. I don't know what more you can do. Did you agree with that? There was nothing more that Claudia Birtles could do.
I think we went on to have further discussions at MDT shortly around that time because both Emma Robinson felt that we had become quite stuck at this stage. There just didn't seem to be a way forward. And obviously Claudia had been trying. She just wasn't sure how much longer she could keep trying. So I think we did have a further discussion.
If we go to 168, page 203, 17th of January. Fourth box down. We'll discuss at MDT Thursday. Consideration will need to be given to discharge as VC is essentially disengaged and we've not been able to monitor him. This is your edit, isn't it? Above it says your edit.
And that may be following an MDT discussion.
Perhaps a conversation with his mum and course tutors to see if there are any concerns currently will be prudent before considering discharge.
Yeah. And what I'd hoped was that maybe if we'd spoken to mum and she'd had any new information or the course tutor, it might give us that sort of third-party information that we need.
You got some third-party information on the 18th of January.
Yes, we did, unfortunately. Yes.
Yeah, so in a completely different direction from the university concerning an assault by VC on his flatmate.
That's right.
And the police were called out. Yes?
Yes.
If we can go, please, to NHFT 0018141. 18th of January, we also see Emma Robinson raising to you, Adela's just been to see me about the above patient, has raised concerns about going to see him in terms of risk towards others. I think also in light of the incident over the weekend, locking students in his accommodation. I know the last contact was a while ago, but I worried for the safety of the staff if they went to see him. I've asked Elle to start having conversations with the AMHP with regard to a Mental Health Act assessment. So I don't see a response there, but did you get that email?
I must have got it because I think a Mental Health Act assessment is immediately triggered.
So after that incident, it looks as though discharge was deflected by that incident and concerns for staff and a Mental Health Act assessment. Is that right?
We clearly had definite grounds at that point to call a Mental Health Act assessment, yes.
What had changed?
What had changed was that there had been an act of clear aggression towards a student, which is very concerning, and hence, yes.
And we know an assessment was set up, 19th of January. We'll be hearing from Dr. Mike Skelton about that. And we know after that assessment, the 21st of January, he was still in the community and was missing medication, and a further assessment and detention arose, wasn't it? Didn't it?
Yes.
Had you followed that in effect on the 19th of January he was discharged back into the community? Did you look at that at the time?
I did.
What did you make of that decision?
I could see it was a a difficult decision because essentially, reading through the notes at that time, the assessing team were not able to find any evidence of psychosis. And without that, it becomes really tricky to, again, have grounds for a Mental Health Act assessment. And secondly, you have to go for the least restrictive option. And I believe that VC was saying at that time that he would be happy to take medication and have follow-up from the crisis team. And so they used that as a testing out period. Now, whilst it wasn't ideal, we are limited by the constraints of the Mental Health Act, which is law.
168, page 225, please. The fourth admission, 3rd of February 2022. Claudia Birtles attends this ward review. Dr. Thangavelu, Dr. Gibson. And if we go to page 226, see at paragraph 2, VC said his thoughts are normal, denies people interfering with them, denies having thoughts people are trying to harm him. And 3 paragraphs down, he was asked about having a depot. So 4 paragraphs down, please, from where it's currently highlighted. He was then asked about having a depot form of medication, and he would prefer not to have a depot. It was explained that the community team thought it would be beneficial to have one. However, he said that he didn't like needles and would prefer to continue with tablets. Did you know he'd said that?
Yes.
Did you know whether he didn't like needles?
I didn't know that at that point, no.
Did you know he'd had COVID vaccines, blood tests, and never been raised?
No, so I wouldn't have seen this at the time, but I think I did see it when I read the notes just prior to my next appointment.
And NHFT 0018527, please, page 1, is an email from you, Dr. Lloyd, to Dr. Thangavelu. You say, as you know, this will be his 4th admission. He's essentially becoming a revolving door. Can we please consider a depot for him and possibly a CTO so that we don't end up back at square one with poor engagement and concordance at discharge? I appreciate the situation isn't straightforward and he manages to conceal his symptoms well. However, his insight remains very poor, according to Claudia, and we nearly need a robust plan at the point of discharge. So you were supporting a depot and a community treatment order?
Yes, and I had a conversation very shortly after this with Dr. Thangavelu over the phone.
And if we have, well, you'll tell us about that, please. NHFT 0019152, page 1. So when did you have the conversation with him?
I can't give you the exact date, but it would have been very soon after I sent this email. It was followed up with a phone call. And a discussion about how challenging it had become for the community team to see VC, to get him to engage in any kind of treatment plan, whether that be medication, CBT.
How long was that conversation with him?
I don't think it was extremely, it wasn't a detailed conversation, but it was a...
You made your position clear?
Yes, absolutely. And I made a plea that could this really be given some serious consideration at this point, because otherwise I just didn't know the way forward.
And if there had been a CTO, who would have been administering the depot in the community? One of your team?
It would have been one of my team.
You, or can nurses do it?
It would be one of the nursing staff.
So, and is there a greater expense attached to depot medication compared with other medication? It's costs a consideration here or not?
I don't think so.
Not as far as you're aware?
No.
And it's not something that isn't authorised? You've given depots, have you, to other people?
Many a time.
Many a time. So would you know now, for example, how many in the team are having patients under the EIP team would be having depots?
I couldn't tell you off the top of my head, but
we can probably get the information.
Yeah, we have a yeah.
So this wasn't a cultural outlier to suggest this. This was perfectly typical of patients that weren't taking medication.
Typical of patients that are non-concordant, yes.
If we go, please, to 168, page 239. This is the ward review, 10th of February 2022, when Dr. Thangavelu discusses the depot option. Paragraph 6. VC said no. He said he was satisfied with the medications as it is. He's been on it for a while. When he's changed in the past, he'd experienced side effects. Again, there doesn't seem to be on that record, does there, a challenge about anything and everything he says about medication. He's not confronted at any time with untruths he's told about them. Do you agree with that? You don't see that anywhere.
I don't see that there's an assertive, kind of stance taken about VC needing to start a depot. I think there is a difficulty here, which Dr. Thangavelu did explain to me on the phone, which is that during this admission, he had not really seen any appreciable evidence of VC having psychotic symptoms. And as such, it made it difficult for him to change the section 2 to a section 3.
I'm going to argue about the capacity of the law. Let me move on, please.
But there's an important point that I just want to make. And without the section 3, a CTO can't be put in place.
No, I understand that, but you could have put a section 3 in place to get a treatment regime established. He hadn't had consistent medication at this point for a long while, had he? Understanding what worked well was going to take time to find out and could have justified an extensive detention to work out the treatment.
He felt that he could not justify, that there weren't grounds to move to a section 3. That's what he told me.
He'll give that evidence. We can hear from him, no doubt. But
okay.
Can we go, please, to 168, page 250, please? Is Mrs. Sue Middleton one of the nurses in your team?
No.
No. Because it looks as though if we go to 250 and 251, in reach to facilitate early discharge, she attends VC's review, 4th admission. So we go to the top, please, 251. So this is crisis at the meeting. 4th admission the past 2 years, and thoughts the community team are he would be better placed on a depot and CTO to risk to others increase when he's unwell. Had you liaised at all with crisis? You clearly had the same views about this. Did you have effective liaison with them to make a united position on that?
Not that I can remember.
Because it looks as though Claudia Birtle's present at some point. This in reach is happening at others. And if both organisations were saying we can't manage it, that was significant, wasn't it?
Yes.
Can we go, please, to 168, page 263? And this is your meeting. You finally meet VC on the 14th of March 2022. And we see your notes in the bottom box. And VC told you that he hadn't missed any medication. That's in the first paragraph. In fact, it was clear by that time that he hadn't been taking medication, wasn't it, over time? Did you probe or challenge him on that and say you clearly hadn't and this has caused you problems or anything like that?
I said to him that we had concerns that he had missed medication, but I think what he said very specifically was that in the lead up to that 4th admission, he had been well, and he seemed really quite angry about that 4th Mental Health Act assessment, and he felt that it had been completely unnecessary because the altercation that had taken place had not been driven whatsoever by psychosis.
And again, did you see independent evidence about that? We know there was a video, a phone video of it.
I didn't know that there was a phone video of it, and I wouldn't have known. I guess you don't know what you don't know.
But you know you can't take what he says at face value about anything.
I accept that it's very difficult, but what I realised at this stage was that we had absolutely no powers to get him to come to appointments. We had no powers to get him to take his treatment, that he had said to the inpatient team he felt persecuted by us. I was worried because I know that Celeste Callacane had also felt that that fourth admission had perhaps not been necessary. I don't think she'd seen any evidence in the lead up to the fourth admission of any psychosis. So it became really difficult to know how to manage this situation where he could almost immediately disengage again unless we at least tried to work on his... Essentially, he was telling us, this is what I'm prepared to do. I'm only willing to work with you. These are my needs. And I just didn't want that immediate disengagement.
At this meeting, you needed to dig deeper and consider other signs of relapse, didn't you? There'd been numerous examples of him masking, concealing symptoms. You were getting a straightforward exchange here.
There was 20 minutes follow-up here. And in that time, it's just not possible to start doing relapse signature work or start digging significantly deeper. What I concentrated on here was the events leading up to that fourth admission, because that was something that would be informing risk, that future risk. So I needed to understand, was that fourth admission, was it driven by psychosis, or was it just an altercation like VC was saying? I just wanted to try and get his perspective on it. I'd already seen a conversation between the victim and Dr. Gibson in the notes.
And you were aware that the screams in the night, in the middle of the night, being heard from his room?
So I'd heard about the screams in the night, but apart from that...
Just pausing there, that's significant, isn't it? His flatmates are saying screaming in the night. Interestingly, you see it in the same statement we went to before, shouting.
So, yes, so I'd read that there'd been screams in the night, but beyond that, the discussion, again, didn't really highlight the seriousness at all of that particular incident.
Did you rely on Claudia Birtles to liaise with Ellie Turner from the university? You didn't speak to the university yourself about what was happening to the other students at the time while these assessments were going on or anything like that?
I believed that Claudia was in touch with Ellie Turner, that liaison was going on, yes.
Were you aware that he'd returned to the university and gave a false name when questioned who he was visiting? That's in the notes as well, isn't it? And emails.
I can't remember. I possibly knew about that, yes.
Very troubling, isn't it, that he's gone back and given a false name?
It's unusual behaviour, yes. And that was actually during his admission, if I remember correctly.
If we go, please, to 168, page 267. Bottom of the page, doesn't attend an appointment with you. Yes, the 13th of June.
Yes.
So how many appointments has he missed with you by now?
I think somewhere in the region of 9.
It's a lot of missed appointments, isn't it?
It is.
Are some of those not recorded? I don't think they're all recorded in the notes.
So there are 5 in between his third and fourth admission. There's 2 when I take over his care. There's a further one, which I think, to be fair, he'd gone into hospital that time, that he'd missed, the very, very first one. There's this one in June and there's another one in August. So I can't remember the exact number. I think I worked out that in total there'd been somewhere between 10 and 11.
If we go, please, to 168, page 270. 4th of August, Gary Carter, who we've heard evidence from. Knocks on the door. He's actually knocking at an address where he's told VC doesn't live. Says at the top he'll take it back to Dr. Lloyd and Emma on Monday to consider discharge to GP, report as a missing person. Then on 9th of August, VC's requested access to his notes, and then it's appreciated that address for that is a Madison Court address. Were you aware at the time, as was apparent in the notes, that was the very property he'd had to leave in January, so he couldn't possibly be living at Madison Court?
No, I wasn't aware. I think because VC had so many addresses at that stage, it was almost impossible to keep on top of it all. There were repeated changes of address from what I can understand, and on several occasions we had turned up to the wrong address purely because we just couldn't keep on top of this constant address change.
18th of August 2022, Gary Carter of VC's applied for access to the notes. Not contacted me after being sent an invite to do so. It goes without saying, if you don't know the address, the invite's not going to be received and responded to, is it?
No.
Telephone conversation with VC's mother, hasn't seen him for many months. Tempted to go and see him, was not at the address. In these circumstances, the police should have been notified, shouldn't they? The police should have been asked to locate him. You knew he'd seriously attacked a police officer.
So we had a conversation specifically about this in our MDT, and we talked about police involvement, and the options open to us at the time were two. One was missing person, to report him as a missing person, and the other one was to ask for a police welfare check.
And what about the third one, using your initiative and saying, this patient we are concerned about, he's not taken his medication, he's had 4 admissions, he's attacked a police officer, we know he's caused harm to students, we want to know where he is, can you help us find him? Do you think they'd say no if you put it like that, as a consultant psychiatrist sufficiently concerned about where he was?
We have had numerous conversations historically with the police and asked for help in circumstances where quite risky patients have disappeared and we haven't been able to find them, and the response has been that it is not police duty to be finding patients with mental health issues, that this is the responsibility of health and social care services. That has been an issue over and over again. And I think when you are faced with that repeatedly, you actually reach a stage where you think, you know what, is it even worth going down that line yet again? So been asking repeatedly for welfare checks, can we have help? And I think, the police themselves are struggling resource-wise, and maybe they can't help.
The very next day, of course, after your discharge, they'd issued a warrant, hadn't they, in relation
yes, well,
to...
we didn't know about that.
Would you ordinarily know that, if they'd issued warrants?
No.
But in this case, even without knowing about the warrant, had you contacted first, at the time you were having the MDT, if we can have, please, 168, page 271 on the screen, as I'd indicated before, he had committed this offence. They were interested in him, even if you had other experiences.
We didn't know they were interested in him.
But even if you didn't, you should have discharged your responsibility in asking them to find him, shouldn't you? And then it was a matter for them. You didn't discharge your responsibility. Instead, you discharged him to the community, to a GP, So let's look at the discussion within the MDT. No contact has been made with VC. It's the top box. For a period of time, despite attempts to make contact and having done cold calls, decision made within the team to discharge back to GP due to non-engagement with view for GP to refer back to services in the future if needed. Now, it's understood neither care coordinator were present at that meeting.
However, the actual decision to discharge, as I have a very clear and distinct memory, took place well before this meeting, and it took place when Gary Carter was present, because in fact it was when he raises, it was shortly after, I don't think it was exactly at the time, but he raises, bring to the MDT a discussion about discharge versus the police being missing. Now, I don't think it took place exactly when he said that, but it was certainly sometime in August.
And he raised two options then, discharge or contacting the police.
That's what he raised,
Yeah.
but we actually talked through much more than two options. We did talk about the two options. We mentioned, we had a discussion about missing person, but we realised that actually VC wasn't missing. He'd had conversations with Mum, there'd been a conversation with his sister, and no concerns had been raised that he'd requested his note, so we knew he wasn't actually missing.
They hadn't seen him. If they haven't seen him, how could they raise concerns? The people living around him, in and around him, were the people who were likely to know if there were concerns, wherever he was.
But his sister had had a conversation with him over the phone, and in previous years...
So had you as a psychiatrist, and you thought at this point there wasn't a problem?
I hadn't seen him, no, at this point.
You'd seen him in March, hadn't you? You'd seen his records.
I'd seen him in March. Yeah. So in March he was well. He had just come out of hospital after a period of treatment where medication would have been administered to him and watched. So he was well at that point in March. I had no concerns immediately at that point about his mental health. Yes, there were historic concerns, but certainly at that point, there was nothing to suggest that he was psychotic or indeed...
If you accepted everything he said to you. The only way you could conclude that is to accept everything you've written down in that box.
But from a mental state examination, there was nothing to suggest that he was psychotic. He was not responding to hallucinations. He was not thought disordered. He just had a solid period of treatment, robust treatment on the ward. I wouldn't have expected him to be unwell at that point.
And this meeting, this MDT, I don't need any more information about it, thank you. Just who was present? Who was present?
This MDT where I remember the discussion about discharge. So
yeah, the one that's recorded here.
Yes, so
23rd of September.
I don't know who was present on the 23rd of September specifically.
What's the minimum you'd have in an MDT?
I don't think there is a minimum number specifically. Again, I think usually that there would be someone that is a team leader or comes from a management background. There'd usually be some sort of medical representation.
And is the pressure from a management background to discharge patients? We know Gary Carter discharged quite a number to the GP around this time. Is it an advantage to the service to just take people off the books if you're not actually seeing them and doing very much? Is it better for you not to have them on there at all?
No, I wouldn't have said so, no.
Which is worse for the service if a patient does something while they're actively being cared for within the service or when they've been discharged and sometime later? Which do you regard as a worse reflection?
It's not something that I've specifically reflected on. It's not something that I would even think about. As far as I'm concerned, in this situation here, we had tried over a 9-month period to engage VC, and we'd failed. We'd failed to engage him. We had not been able to see him as often as we'd wanted. I certainly hadn't been able to. We had not been able to get him to accept his treatment. We had no powers to compel him to come to appointments. We had no powers to enforce treatment without a CTO.
So you felt redundant, you couldn't do anything else?
We felt absolutely redundant.
Can I just ask you, I need to be mindful of the time, we've got to break shortly. NHFT 0000123, page 1, please. And this is the discharge letter to the GP, and it's signed by Sharon Heath. Why doesn't it have your name as the consultant psychiatrist responsible?
Because discharge summaries usually come from the care coordinator, and I don't know why Sharon signed it on this in this case. And I think the response, the consultant responsible, is an interesting word, because at the end of the day, I'm a community consultant working with a team. I'm not someone with ultimate or sole responsibility. It's not as though
you're a person with authority and power if you choose to use it.
I have authority and power, so does the team leader, so does the clinical lead. The care coordinators have all of the knowledge. They do, as you can see, the vast majority of the work. The leadership across the team is shared and distributed. We have pharmacists that provide pharmacological leadership. We have psychologists that provide psychological leadership. So it's not as if I am the only one person here that has all of the responsibility.
Pooled GP list, what does that mean?
I don't know.
Because there isn't a named GP, is there? There's no connection with a human being out there.
No.
There's no description of why the decision's taken.
No.
No rationale, no safety plan, no management plan.
It's not a good discharge summary at all.
It's appalling. It's not a discharge summary at all. It's I've washed my hands away.
Yes, it's not a good discharge summary at all. I completely agree with that.
It's not sent to the family.
No.
And it could have been sent to the family, couldn't it?
Yes.
Even though you couldn't give you thoughts, information directly from him about his health, you could have sent that to the family and should have done.
Yes, I think all of that information should have gone out. I spoke to Sharon Heath about it, but this was much later on down the line because I hadn't seen this at the time. And I think her response was that all of that information should have been attached with this letter. But for some sort of, I think, some kind of administrative failure had led to just this covering letter going out. That was her response.
Last question for me, please. NHFT 0004820, page 3. You said this morning that you'd been instructed not to discuss events with colleagues.
That's right.
And this is an email 27th of February 2025 to Claudia Birtles and Sharon Heath. I've been asked to answer a set of questions in relation to a complaint made against the Trust by the victims of VC's family. Given my very limited involvement with him, I'd appreciate a meeting up so that we can tackle some of these questions together and formulate a response. Could we find a time fairly soon to do this, please? So it looks like you did have conversations subsequent.
Yes.
So had you forgotten that this morning when I asked you about that?
And this is at a point where everything was out in the public domain. So we were then told it is okay to now have those discussions. So initially, in 2023 and 2024, before things were in the public domain, we could not, but then afterwards, those conversations were taking place.
The inquiry has a statement from Stephen McGowan, Chair, the reference number WITN 03190001, so we'll upload that later, in relation to audits of early intervention psychosis programmes. You, I don't think, at Nottingham have ever had a peer review, have you, across the service?
An audit across the service?
Peer review. Peer reviews, members of the review team encouraged to share recommendations from their own services and experience with others. Have you had that within Nottingham?
I don't think so. I've not come across a peer review being done within our trust.
Do you think that would be helpful to have a review from another trust elsewhere?
Yes,
Chair.
yes, of course, yes, absolutely, yeah.
Chair, those are my questions. It may be a good time
you.
for the break
Yes.
before others ask
I think
questions.
we'll take a relatively short break. So if we take a break till we start again at 1:45. Thank you. Mr. Maloney.
Good afternoon, Dr. Lloyd.
Good afternoon.
The last document Miss Langdale took me to was a document NHFT 304820, and I'd like to go to that if I could. It was an email from February that you explained the significance of to Miss Langdale and her questions. And if I could please, I'd like to go to the last page of that, well, page 5 out of 6, please. And to set the context for these emails, that this is to you, and it's from a lady by the name of Anna Hilly, and it's about the investigation. And we can see halfway down the page, in preparing our response, I and an external psychiatrist will be interviewing the staff who are involved in specific aspects of VC's care. And then in the next paragraph, we will provide in advance the questions pertinent for yourself that I and Dr. Reid will be seeking to respond to. And so this is essentially an email to you saying that they intended to interview you and that they would send the questions that were pertinent to you in advance so that you could consider them. If we go up to page 4, you say thank you to Anna, and you say you'd really appreciate early access to the notes so you have ample time to read through all the notes again and prepare for this interview. It's been some time since I did this. I only worked for 2.5 days, so my prep time is very limited. I look forward to hearing from you. We go up and we see that Teresa Dory is sending you the notes, and you say thank you for that. And then if we go up to page 3, Katie Crooks checks that you have access to the notes, and further up, then you say, and this is on page 3, and this is from you to Claudia Birtles and Sharon Heath. Good morning, Claudia, Sharon. I've been asked to answer a set of questions in relation to a complaint made against the Trust by the family of VC's victims, it should be. Given my very limited involvement with him, I would appreciate meeting up so that we can tackle some of these questions together and formulate a response, ? Could we find a time fairly soon to do this, please? Many thanks to Hina. And then we see that Sharon Heath gives her dates of availability, Tuesday 11th, Thursday the 13th. You say that unfortunately you're on leave that week. Don't worry, you'll meet Claudia and use the notes to put a response together. Let me know if there's anything you want to add with regards to the discharge letter process and contact with family. And then Sharon Heath says that she could meet the following week, and then you organise the potential Teams meeting. Now, isn't that just exactly what Gary Carter said, that you wanted everybody to be on the same page?
It was really important here for me to get both Claudia and Sharon's views, because many of the questions that had been put to me were not things that I had been directly involved with. For example, the discharge letter question. I wouldn't have written the discharge letter. It would have come from Sharon Heath, so it was really important to have her input with regard to that question. And I must have read through all the questions and realised that there were several questions where Claudia, as lead clinician, would have had a lot more understanding and knowledge than myself. So yes, absolutely. I think we've always worked as a team, and that's That's how early intervention in psychosis teams work. It's all about team working, team decision making. So everything we do is team oriented. And so in answering many of the questions which were in relation to the team, yes, of course, I will ask for their opinion on many of the answers so that I make sure I give the best and most accurate answer. And it's not just based on what I think or believe.
But these were questions directed to you that were pertinent to you, as it said. And
They
so,
were not pertinent to me. I read through them, and many of those questions, and I can't remember exactly what they are immediately, but I'm happy to, if anyone's got a copy of those, we can look through them and I can show you exactly how they're not specifically pertinent to me. They're things that maybe the trust believed I should be able to fully answer myself, but in actual fact, when I looked at the questions, there was very clear evidence that both Claudia and Sharon would be able to help immensely in terms of their involvement in those questions.
but the questions were to be asked of you. Surely your answer, if you weren't able to answer, was to say, well, that question should be asked of Sharon or it should be asked of Claudia, rather than you giving an answer, which was a collective answer.
I was told very clearly that these questions needed to be answered by myself, that there was a recognition that I may not have been the person leading specifically in relation to this, but I was told that I needed to give an answer. And this happens quite a lot in complaints and various scenarios where questions are put to me by a patient or a family, but actually it's not pertinent to me. It's what the family may think is pertinent to me. There is a difference.
So, when you said, given my very limited involvement with him, I would appreciate meeting up so we can tackle some of these questions together and formulate a response, was that meaning that the response would would simply be that they would feed in and you would give any response that was from you?
Could you repeat that question?
Was the response to come from you or from the collective who met to discuss the questions?
The response would predominantly be from me, but I would have used their knowledge, which for specific questions, it was really important for them to have an input.
If you disagreed with them, would you have still maintained your position?
Which is?
Whatever position you were taking, that whatever you thought.
Not if it wasn't something that I had enough knowledge about. I would have to defer that knowledge to them. That's why I'm asking them, because I wouldn't have necessarily known the answer.
And so, is it your evidence that you did not say to Gary Carter, we need to all make sure we're on the same page here?
And when apparently did I say this to Gary Carter?
In a car, I believe. You gave evidence that you were all in a car after a meeting and you said we all need to be on the same page here.
After a meeting where?
Car park.
In a car park.
In a car park.
It was in a car park. Do we have any more information beyond that? Do we have a date for the meeting or minutes that I attended this meeting?
Would you not remember if you'd said that to Gary Carter? So would you not remember it if you'd said that to Gary Carter, Dr. Lloyd?
I don't recall saying that to Gary Carter, which is why I'm asking for clarification.
Right. What if you said something like that to Gary Carter in the early days, is it something you would remember or not ordinarily?
I would not have said anything to Gary Carter in the early days because right at that initial stage, particularly in 2023, we were told very clearly not to be talking about the case to anybody.
By 2023...
No, by 2020, but it was in...
No, I'm talking about... sorry, I'm moving on. I do apologise.
Oh, sorry,
that's my
sorry.
fault. By 2023, before discharge, Miss Robinson gave evidence that EIP had lost VC yesterday. Did you see that evidence?
I was travelling, but I do believe I briefly read a transcript. So yes, I think I did see that, yes.
And you've answered questions by Miss Langdale today
Yes.
about how essentially you didn't know what to do with VC by the time it came to discharge.
By the time it came to discharge, yes, we were struggling to find him. It had become incredibly difficult. He had become very skilled by this stage at avoiding services.
Given that he was very skilled, it was very difficult to find him, why didn't you contact the police to see if they could find him?
Because we knew from previous experience that every time we have contacted the police asking for help, when there hasn't been clear and imminent risk to life or limb, and that's what we're quoted, there should be clear imminent risk to life or limb. Otherwise, it is not their responsibility to be getting involved in cases relating to mental health issues, that it is the duty of the mental health team or social care. Right. And that's been a repeated response from the police.
Now, one of the addresses he gave was 209 Ilkeston Road, wasn't it? Do you remember that?
I can't remember any of the addresses off the top of my head, but yes, if you say that's an address, I will accept that.
Have you ever been told that the police assessed that house as linked to drug dealing?
No, I didn't know that.
And that there were reports of a firearm, a black handgun, being seen there on the 26th of July 2022.
I didn't know that.
If you'd contacted the police when considering discharge, when you couldn't find him, and you might have been told that, would you have been very concerned about VC associating himself with that address?
Possibly, yes. It depends whether he was directly involved in the drug dealing.
Can we please look at the document WITN 0163002? Now this is, do you remember VC asking for disclosure of his medical records at the fourth admission?
This was shortly after the fourth admission.
Yeah. Well, this document is in fact August 2022, but the date on it is actually the 21st of February 2022, and it's taken time. Gary, it's in the Rio as August, but...
Yes, I remember VC requesting his notes, yes.
Do you see the address 15 Madison Court?
I do see that, yes.
Did you see as well that he appears to have scrubbed out 209?
No, I can't. I'm not sure what he scrubbed up, but I can see a scribbling.
Yeah. I'd like to ask you about discharge, if I may, please. You were asked about the importance of the care coordinator's views by Miss Langdale.
Yes, it is important.
Yeah. But you accept that Gary Carter was not present at the meeting where he was discharged.
As I've explained...
No, you said, of course, that you thought you'd had a meeting with Gary Carter before then. Yeah?
The discharge decision was taken before that final date. What I remember of that final meeting was that it was administrative. I can't remember any detail except it felt like a rubber stamping, because in a MDT meeting, it's the care coordinator that brings cases for discussion. Now, Gary Carter wasn't there, so I cannot understand who would have brought one of his cases for discussion. It doesn't quite compute with me. It's very odd. The decision to discharge, as far as I can remember, had been taken sometime in August. Gary had come into the room and he had said, "I have done everything that I possibly can now. I've completely run out of all ideas." And I have a clear and distinct memory of him saying that and having a discussion about the options. What else can we do? Should we think about crisis, Mental Health Act admission? Should we think about police? And that's when there was the discussion about asking for either a welfare check or missing person, both of which we decided not to go for the reasons that I have put in my statement, and that at that point we felt that there was no other option really apart from discharge. I do not believe that the meeting on the 22nd was a decision-making meeting. I think it was a rubber stamping of discharge, because I have no recollection of any kind of decision being made on that day.
You'd previously agitated for VC to be given a depot, hadn't you, by an email to Dr. Thangavali. You discharged him without any depot, didn't you?
Yes, because we had no choice but to do so. We had run out of options. There was nothing else at that stage that we felt we could do. We'd lost him. We didn't know where he was. His family didn't know where he was. We had lost him. We had reached that position where, after 9 months of trying, we felt that there was nothing else that our small team could do. We didn't have the skill set of an assertive outreach team. We didn't have the ability to track and trace someone who was changing addresses rapidly, who was potentially even not in the county.
So that was it.
So we had reached that position where we didn't know what more we could do.
Yes.
And under those circumstances, what are the options?
Can I just ask you about annual job planning very quickly? Does annual job planning take place with the clinical director?
Yes.
And are hours and workload discussed?
Is what discussed?
Are hours and workload discussed at the annual job planning?
It is discussed, yes.
And it's a formal process, that, isn't it, the annual job planning?
It's a formal process.
And if you had an unsafe service, should it be escalated to the medical director or the chief executive?
I didn't feel that service was unsafe.
Thank you very much, Dr. Boyd.
Yes, Ms Cartwright.
Good afternoon, Dr. Lloyd. I ask questions on behalf of the survivors. Now, Dr. Lloyd, you've told the inquiry today that there was a known issue regarding documenting the MDTs. And I think you've said that it had been raised repeatedly through the consultant route.
No, I don't think I'd said that.
All right, well, let me be clear. So we've got no records of the MDTs.
That's correct.
And so you're saying that wasn't known within the trust, that there was no one taking notes of the MDTs?
So, as far as I was aware, the MDT meetings were not being recorded across a number of teams across the trust. There was no administrative support to do that.
Well, that's what I understood your evidence to be. But can I just be clear then, because you referenced something that was raised repeatedly by the consultants that was being escalated within the trust. Can I be clear what you were speaking about then?
That wasn't the MDTs. I think that was to do with caseload, I believe.
All right.
Yes. So it was the fact that all of us had extremely inflated caseloads for the amount of hours that we were working, and that's something that's been raised numerous times in consultant meetings and forums.
Now, you didn't detail that within your witness statement to the inquiry. Why not?
So what I mentioned in the witness statement was that the 3 sessions that I had, the 12 hours that I had allocated to EIP, didn't feel sufficient at all.
Well, that's something quite different to you saying all of the consultants were raising with the trust the workload. That's very different. That's an issue of patient safety. It's an issue of clinical governance, and you've given evidence as if this is a relevant factor that was well known in the trust. So why did you not include it in your witness statement?
My witness statement was very much guided by the questions that were put to me.
So if you had relevant evidence that wasn't covered by a question, you decided to leave it out of your statement?
I don't believe that this is an issue just for our trust. I think that psychiatry is chronically underfunded nationally. That's my understanding. So I think this is a well-known fact. across psychiatric services. And I wasn't specifically asked about my views on services locally or nationally. I was purely asked a series of questions to help the inquiry to come to their conclusions regarding this case. You know, I'm not sure that what you're asking was necessarily relevant specifically to VC.
Right, but you're essentially saying there's a document trail that exists where the trusts were being notified about issue as to workload of the consultants in this team.
It wasn't just this team. I'm talking about consultants across adult mental health.
All right, well then let's just deal with the MDT then. So you knew that the MDTs were not being recorded.
That's right.
And so you essentially said to Ms Langdale, well, there's nothing more to say on it. But actually, you do have something more to say on it because you have your own professional obligations in respect to recording. Would you agree?
So I raised it with the team.
No, that's not the question.
So
you have professional obligations governed by the General Medical Council in respect of record keeping and ensuring that you record your relevant decision-making and actions. And even more so, when you're attending MDTs where you know they are not being documented and you are party to them, even more so, this raises the obligation on you personally and professionally to document your involvement in the MDT. Would you agree?
I think if I'm expected to document every single decision that's made in the MDT, that's all I would have time to do. Right. It just wouldn't be possible. But there are somewhere in the region of 25 to 35, 40 patients that are discussed. It just would not be possible for me to do that level of documentation. It would be impossible. So that's all I would do in my 12 hours.
Well, you are the responsible clinician, the community consultant.
I'm not the responsible clinician, no. That is a legal term.
Well, you are VC's consultant.
I'm the community consultant, correct.
But you were VC's consultant.
Yes, I am.
So after, well, you were supervising Dr. Burry as your ST5.
Yes.
And I'll come on to deal with that. But after he then left and handed VC back over to you from July of 2021, you were VC's community consultant. Yes?
Yes.
And so in terms of MDT, where VC is being discussed and decisions being made about him and his care and his medical provision, you had an obligation to make formal recordings of your work that were accurate, contemporaneous and legible. They may have been brief, but you had a requirement yourself to make those notes. Would you agree? And the guidance makes clear that you have to record decision made and actions agreed. And therefore, even if other people weren't doing notes of the MDT, you personally should have been making notes.
The decisions that were being made were not unilateral decisions being made by me. They were team decisions. And the team member that has clearly been identified as being responsible for recording in the MDT notes is the care coordinator. And so it is their role, primarily, as lead clinician to be recording in the notes, not mine. I am one member of the team, inputting and giving my opinion at times when needed. There are many other opinions coming from people.
But as central member of the team,
I'm not a central member of the team.
Because you are a consultant psychiatrist. There were no other consultant psychiatrists contributing to those MDTs.
There wasn't, but I am not necessarily the central member. I'm not making unilateral decisions. These are joint team decisions. The care coordinator is bringing the case for discussion. It is their responsibility, as far as I'm concerned, to be recording, and that's what I've been told, that is their role, it's their duty. It was what I was told at the beginning. We should have had administrative support. We didn't have it. But as consultant, I would not have the time or ability in 12 hours to be making those detailed recordings.
So then when you were, as you've told us on a number of occasions, you reviewed VC's notes and noting that the care coordinators were not documenting the MDTs, what did you do to flag to them then? If you say it wasn't your responsibility, there are not notes of these important MDTs.
That's when I flagged it to the team leader and said, this isn't happening, we really need to have administrative support. And she said, no, that's just something that we can't get, that resource is not available to us. This is not just our team, this is across many teams within the Trust. And when I spoke to my peer group, I found out actually that was in fact the case. And so it wasn't just me that wasn't, sort of flagging this up specifically. There are other consultants in the Trust that are in exactly the same position. It's a shared responsibility, isn't it? It's not down to me to make huge changes to what's going on across the Trust.
Well, I'm going to suggest to you, in fact, what you're trying to do is limit your responsibility and the leadership you should have had as a consultant for VC's care and for VC's decision to be discharged. Most aptly typified by the fact that you didn't even bother to draft the discharge letter handing over continuity of care to the GP when there was no care coordinator involved in that meeting. Would you agree?
The decision to discharge VC was made well before that meeting when Gary Carter was present. It was made in August, he was present, and he should have drafted the letter as all the other care coordinators do. Whenever there is a discharge meeting where a patient, family, GP are all invited to clinic, and I'm there and it's my clinic, I always draft the discharge letter on every occasion. On this occasion, there wasn't that meeting because VC was not present. It was an MDT discussion, and for that reason, I didn't draft the letter because it was an MDT discussion, and it should have been the care coordinator who brought the case. And in any case, even when I do the discharge letter in clinic, there's also a second letter that goes out from the care coordinator. So there's usually two letters that the GP receives.
Let's just look, because essentially your evidence today that the decision to discharge was made before the September MDT is, I think, I'm going to suggest you've changed it because you've now realised in the correction you made that Gary Carter wasn't in the MDT. So can we look at what you did say, please, in your witness statement, WITN 0357001 at page 125. So paragraph 347 on page 125. Thank you. I was present at this 23rd of September you deal with the discharge, but you say I was present at this MDT from memory. So this is the MDT of the 22nd of September. Emma Robinson, Gary Carter, CCO, Abigail Parsonage, Adele Pinder, Francis Doherty, Paul Eames were all in attendance. There were other team members in attendance as well, but I'm unable to recall exactly who they were. It was decided to discharge VC from the service as a non-engaging patient despite a 9-month period of trying to engage him in the community. From October 2021 to September 2022, we reached a point where it became very clear that VC was actively and intentionally disengaging with service and his medication and so on. You don't say in your witness statement there, we made the decision before then in August, and I'm going to suggest that's the evidence you're now giving because you've realised there was no care coordinator in that MDT.
That's not correct. I have written very clearly my recall, my memory of the meeting. The only thing that I have got wrong here is the date. And the reason for that is, whilst I have clear memories of events and meetings, it's not always very easy to remember dates in detail. And what I'd done, I'd gone to the notes when I was writing my statement, and I'd used dates in the notes as anchors. And so when I'd seen that Sharon Heath had written in the notes that the discharge decision had been made on the 22nd of September, I'd attached my memory of what had happened to the 22nd of September, thinking that must have been the date when we had this conversation. And so, essentially, yes, I'd made a mistake with the date here, but everything else I've written, including the fact that I was certain that Gary was present, which I was because he had been present.
Well, it's for the chair to make more evidence what she wishes to make.
That's absolutely fine.
But now then, we know that Gary Carter wasn't there.
He wasn't.
And we also know the previous care coordinator wasn't involved. So back to the question that you avoided before, why therefore did you not write the discharge letter providing the continuity of care back to the GP, you're discharging VC as his consultant from secondary mental health services back to the GP? Why did you not write it?
Because I assumed that it would be written by Gary Carter as soon as he returned, which was actually the week after. Because that's what the care coordinators always do. And if that's their role and responsibility, I think it's...
I'm going to suggest to you, where it's continuity of care, again, good medical practice makes clear as well, you have your responsibilities, again, contained in good medical practice, that where continuity of care is being passed between teams, you have your responsibility to ensure that responsibility for safe patient transfer between teams. And so you had a role, a significant role to play here, where you have a psychotic, schizophrenic, a patient who is non-engaged, not complying with medication. If ever there was a discharge letter that needed to be carefully crafted, it was this one, and you should have written it, including your rationale for why you were discharging VC from secondary mental health.
If that's your view.
Well, then can we then look at your notes? Because I'm going to suggest this again shows your poor note-keeping and record-keeping. So let's just look at two examples of when VC failed to attend and how your note-keeping is non-compliant with the policies that applied at the time regarding do not attend. Can we look in the Rio, please? NHFT 168. And I think I'm going to suggest that these entries really do show that despite the complex and picture for VC, just the level of care and attention you were giving to VC's case. Page 267, please, your entry for the 13th of June. Bottom of the page, we've got 13th of June over the page, please. Medication, aripiprazole. VC did not attend his 10 a.m. appointment, CPN to reschedule. Now, in terms of the trust policy, perhaps we'll just look at another example. 269, please, 1st of August. Again, your note for the 1st of August, aripiprazole. VC did not attend his 11 a.m. Thank you. Did not attend his 11 a.m. appointment. Another will arrange by his CPN. Now, would you agree that this was an opportunity when you were making recordings to actually do what you should have done in accordance with the policy, which to have documented calls to GP, calls to family, your risk assessment at that time in light of his non-attendance?
So as I've explained to you, that we follow the trust policy with all of our DNAs, and in any one clinic, there could be a number of DNAs, particularly with psychotic patients. Sometimes it can be anything up to 50%. And I think if each time I'm almost cutting and pasting,
Well, it's not cut and pasting.
Well, it almost isn't it? It's like discussion with the CPN who is in the room. Have you got any concerns? I have looked back at the notes and I have found that there is nothing in the last few entries which are of concern. And then the next steps are that the CPN will now contact the patient by phone, and that could be immediately or a bit later in the week if we've identified no concerns. It would be what would be really helpful here is if there had been DNAs, there was almost like something that we could tick really quickly to say these things are done. There's essentially like a checklist for us. That would have been helpful, because essentially each time we would just be saying the same thing in terms of repeating what we're doing as far as the trust DNA policy is concerned, and that's what we follow.
So did you call VC's family?
I didn't, but the CPN, the care coordinator who is with me in the room, often she'll call immediately while...
Well, again, the purpose of records and documenting it is then it shows it's been done.
Yes, and she does document it. So if you look at the next entry, phone call to Valdo, 3rd of August. So
that's not what the policy required on the day that a patient does not attend. It's contact the GP. And bearing in mind you've got a slot now on your busy schedule where a patient has not turned up.
We may have a slot, but actually what we're doing in that slot is me and the CPN are having a discussion. We're looking through the notes, we're having a discussion. That slot actually gets used up, making sure that all the actions from the DNA policy are followed.
There's no evidence of that, and most significantly, there is no evidence of what you were required to do when VC did not attend, which is the risk assessment, a documented risk assessment.
It's not a risk assessment, actually. It says level of risk in the DNA policy that we follow. The one that you will find that I have referenced, it says the level of risk. And I don't know which DNA policy you're looking at.
Well, I'm looking at the one that was in place in from September to 2021.
I think there might have been two in place.
Well, there was one before, but again, that had requirements. But the one you were required to follow, NHFT 0004725, please. And so is it your evidence you were following an earlier iteration of policy and not following the policy that was, in fact, the promulgated policy for the trust at the relevant time?
I was following the policy that I had.
Well, let's look at this one. So this is the trust version, 7th of September 2021. Is it your evidence to this inquiry that you were failing to follow the trust relevant policy in 2021-2022?
So this was a new policy, was it?
No, this is the policy, version date September 2021. It's the live policy for your relevant involvement. So is it your evidence you were failing to follow the trust policy?
No, I believe I was following the right policy, and I believe it's one that I have referenced in my...
Well, let's just
my statement.
Let's look at the other policy.
Put that up, and we can have a look at the date.
40417.
I'm happy to look at the one. I'm happy to look at the date on the one that we have in.
So this is the earlier policy, I think, one you reference. Is it this policy you're saying you were following?
I can't tell you from looking at the front.
Well, perhaps then let's just go to page 7, which would show what you should be doing when a patient doesn't turn up. Was it this policy you were following?
So actions will be taken by the clinical lead, which wouldn't be me. I'm not the lead clinician. I mean, I don't think it was this policy, but I'm just looking at it now. The clinical lead must make repeated efforts to contact the patient via telephone, on the day of the missed appointment, which they do, which is the care coordinator.
Well, that's what. Let's just leave aside the content. I just want to try and crystallise what you were following.
I don't think it is this one. There is another one which I have referenced.
Then let's just look then, please, back to the September 2021, which is the 4725, please, NHFT 0004725. And go to page 7, please. And so were you following this policy?
Yes, that's right. Immediate assessment of the patient's level of risk.
Yeah, so...
So level of risk is not a risk assessment. In an outpatient clinic setting, an assessment of the patient's level of risk may not necessarily require the oversight of the full MDT and must be conducted by a member of medical staff or another practitioner. And that's what is conducted between myself and Claudia Birtles. The requirement for either a full MDT risk assessment, so that's the full MDT risk, or a risk assessment undertaken by an individual member of staff, will depend on. So they're asking us to look at a level of risk.
And that's what I'm asking you about.
And that's what we do. And so
that's what I'm suggesting to you. So it doesn't have to be a formal document as in the risk assessments that were... But you needed to document in your notes, in your clinical entry, your assessment of risk, which is a risk assessment. And that's what was needed and required. And there's no evidence anywhere that you would at any occasion consider that for VC, and you've certainly not documented it. And so I'm going to suggest that you now say you did that.
We always did that for every
well, there's
patient.
no evidence of that whatsoever.
Cartwright, I ultimately have to make a decision about this, and so you're over time now by a long way.
No, well, I'll leave the other point.
Thank you.
Thank you.
Yes, Mr. Straw.
Dr. Lloyd, I represent VC's family. It's right, isn't it, that you quickly after the June 2023 attacks realised that you'd made a serious error by discharging VC into the community to his GP. That's right, isn't it?
No, it's not right.
And since then, your evidence has been aimed at covering your back rather than telling the truth. That's right, isn't it?
That's not correct.
Well, let's look at a few examples. You said earlier on that Celeste Callacane felt the fourth admission had not been necessary. Do you remember that?
That had been told to me by Claudia Birtles after the fourth admission, and I had also read in the notes that Celeste Callacane had felt that he hadn't been unwell and that admission should not have taken place. I specifically remember reading that at the time.
Okay, well, let's look at the notes. NOCC, please, up on screen. 5043. You can see this is the 28th of January 2022 AMHP report by Fiona Parker. Could we go to page 4 of that, please? We see at the top, telephone call from Celeste, unaware of the situation and a little exasperated, and then noted his belief in conspiracy theories, does not object to admission if we think he needs this.
Okay.
That was her view, wasn't it? She didn't anywhere suggest.
It doesn't sound like she objected, no, but I certainly got the impression from some of the excerpts in the notes that she hadn't felt that he was unwell in the lead up to the admission, or indeed after he'd been admitted, when in the past she'd been really quite assertive in coming forward whenever she had any concerns, even conversations on the phone when his voice had sounded a little bit unusual. She would ring up and say he doesn't sound right. Whereas on this occasion, she'd had a number of phone calls with VC in the lead up to the admission and hadn't really raised any concerns, and had, in a telephone conversation and a ward round, suggested that she just hadn't felt that he'd been unwell this time.
Hadn't raised any concerns. That's your evidence.
Certainly not, as far as I'm aware, in the lead up to this admission.
Okay,
I wasn't aware if she had.
Can we have Rio's, the 168 document, page 223? There's an entry the 2nd of February there in the middle of the page. Telephone call to Mother Celeste. she explained Valdo seemed normal to his parents until they heard about the incident. And then she talks about speaking to him on the phone, and I'll come back to that. Celeste was worried about him. She thinks he's scared of mental health services and feels persecuted by them. So on the face of the Rio notes that you had read, she was expressing concerns, wasn't she?
She's saying that he's frightened of mental health services, he feels persecuted by them, which would explain why he had disengaged and why he'd missed all the appointments with me, yes.
Well, it was an indication that he was relapsing into paranoid delusions, wasn't it?
She didn't suggest that at all. She just said she was worried about him.
She's not a psychiatrist.
No, of course she's not. But I'm just saying that she's saying that he's scared of mental health services and feels persecuted by them. That doesn't suggest that she feels he's been particularly unwell.
Well, let's take another example. Earlier on, you discussed your reasons for discharge, and you referred to the August 2022 phone calls referring to Celeste, the mum, and also the sister, and you said no concerns had been raised.
That's what I was told by the care coordinator, yes.
But that's misleading, isn't it? There was, at no point did they say they weren't concerned about him.
Right.
Rather, what they did say, and we've seen the note earlier, was that Celeste had had no face-to-face contact with VC for many months. Do you remember that note?
I remember that note, but I also recall that there'd been a conversation with Sister, and I specifically asked Gary, when you spoke to Mum and when you asked about Sister, were any concerns raised? And he said no, she didn't raise any concerns on this occasion at all. And in fact, she seemed, and these are Gary's words, she seemed a little bit irritated by me contacting her.
You mentioned a couple of times there significant pieces of evidence about things you say Celeste said, which we don't see on the medical notes at all.
Such as?
Well, the one that you just mentioned.
Just that one, yes.
Irritated. That's not on the notes, is it?
That's not, but that was communicated to me by Gary after, because I specifically asked, did Celeste express any concerns? And the response was no. But there had been a conversation with Sister, but no concerns had been expressed.
I suggest the reason it's not on the notes was because it wasn't ever said. That's right, isn't it?
What was never said?
Your evidence just now about Gary Carter saying, well, Celeste was irritated, she didn't raise any concerns, that was never said, was it?
That was said.
Okay, so I just referred you to the point about Celeste not having face-to-face contact for many months. It was obvious from an early stage, wasn't it, that face-to-face assessments of VC were important because he masked his symptoms.
Yes, it was important, yes.
And so it was significant, wasn't it, that Celeste hadn't had face-to-face contact with him for many months?
That was significant. It was significant that we haven't been able to see VC.
And you were aware as well, weren't you, that VC had withdrawn consent for the medical team to share any information about him with Celeste towards the end of 2021?
That's correct.
And so she really wasn't in a position to express a view about his mental state, was she, in those circumstances?
Because she hadn't seen him.
She hadn't seen him, she wasn't being given any information from the medical services about him, she didn't have a basis to properly understand what his mental state was.
And at that stage, unfortunately, we didn't either, because we hadn't been able to see him.
But I'm asking about Celeste, and you placing weight on, as you say, no concerns having been raised. I suggest that in this contact, in all of this contact, because of all of these reasons, you were just wrong to place any weight on the fact that she had been phoned up and she said, I haven't had face-to-face contact with him for many months, and that was it.
But there had been a telephone call with Sister, and also on the 31st of August, I understand that Celeste had a conversation with VC. So I think there were 2 conversations with him on the phone, and whilst I accept they weren't face-to-face, I think because she knew, I got the sense that she knew him well, because previously when she'd had telephone conversations with him, even the tone of his voice, she was able to pick up that there was something wrong, because she called us and said, he sounded really different on the phone, I'm very worried. So, you know, I'm not saying that it's easy to ascertain concern over the telephone, but if there had been something that she'd picked up, surely she would have told us.
2 other examples. In your witness statement, you discuss the university. You discuss VC's university. So paragraph 143, you refer to your meeting with VC on the 14th of March 2022. And you say, I noted that VC was on track and coping well with his degree. Do you remember that?
He told me that.
Well, what you say in your witness statement is, I noted VC was on track and coping well with his degree. That's what you say, isn't it?
Yes, if that's what I've written, yes.
And again, it's not true, is it?
I did later find out that he had decided not to pursue the Masters and had decided to go for a lesser degree. But he was on track with that, and he achieved a good 2-1. That's my understanding. So it wasn't that he wasn't on track. He didn't perhaps get the Masters that he'd wanted originally, but he still gained a university degree, which is of a, you know, mechanical engineering is incredibly tough. And here's a man with mental health issues who manages to gain a 2-1 in a really tough subject.
Where did you get that information from?
I think that's pretty impressive.
Yeah, he got the 2-1 based on his marks up until early 2020, didn't he? Not on what happened afterwards. That's right, isn't it?
Yes, I guess it's up to 2020, yes.
And could we have the Rio back on screen, please? It's 168, page 210. The 168 document, sorry, page 210. So top of the screen here, 24th January 2022, an entry from Ms Birtles. VC does appear to be struggling with his studies. Feedback from course leader indicates that VC has failed to complete a whole module and has been submitting exams too late. And we saw a similar note from Dr Manzar's 28th of January 2022 assessment, which noted that VC was failing in his courses and the university is threatening to terminate his course. Now, when you say he was on track, again, that wasn't true, was it?
When did I actually say that? What was the date?
Sorry, when did you say he's on track? You just said it.
No, as in, you brought it up, it was in my statement. Do we have a date for that? Can we get that
just
up?
a moment ago, when you were responding to me about his university course, you said you thought he was on track.
It's what I had written in my statement, apparently.
And that's what you said to me in oral evidence, in your sworn oral evidence a few moments ago.
It's March 2022.
OK, March 2022. Yeah, thank you. And was he back on track in March 2022? I'm not sure. Perhaps he was. Certainly, that's probably what he told me.
OK, and
I'm really not sure what the question is here. At the time, he told me he was back on track, and that's what I'd noted down after my appointment. Is that the question?
Well, I think we've been through this in enough detail.
I think we have, haven't we?
Last question. Last area. You noted earlier that the decision to discharge had been made in August 2022, and the decision had been made on the basis that Mr. Carter came up to you and indicated that...
He didn't come up to me. He came to the team meeting and brought up with all of us that he had done everything that he possibly could, and we needed to consider either reporting VC as a missing person to the police or discharge, and we went on to have a discussion about a number of options.
So you'd done all you could, there's nothing more you could do, and so the decision was made to discharge him.
The decision was made to discharge because at that point in time, we had no powers in the community. We didn't have any powers to compel him to attend appointments. We didn't have any powers to compel him to take his treatment. We tried for a 9-month period to do so. It's a team that essentially was not capable or resourced to manage someone like VC, who was actively and deliberately disengaging, changing addresses, telling us he was abroad, us not being able to find him.
And you'd done all you
Mum
could.
didn't know. We felt that we had done everything that we could at that stage, and we didn't know what other options there were.
Sure. Can we have the Rios back on screen, please? Page 270. And the bottom of the page now, please. So it's 31st of August, the end of August. So after you've made the decision to discharge on your evidence just now, after you come to the point when you thought you'd done all you could, you couldn't do anything else, telephone conversation with Celeste. She'd not seen Valdo face-to-face for many months, but she had a telephone conversation with him in the last week. Celeste attempted to go and see VC, but it was not the address she was familiar with. I feel, so this is Gary Carter, in the circumstances, I will arrange a visit with a colleague to go out and see VC to determine his mental state and general well-being.
Well, that should have happened as soon as we got the new address. And in fact, that was on the 9th of August when we got the new address. And so as soon as we got that, there would have been a suggestion that Gary go and visit VC at that new address. So I don't know why it's taken another 3 weeks for Gary to decide at that point that he will go and do a home visit when we've had the address for a significant length of time.
This contradicts your evidence, doesn't it? You gave just now.
Which evidence?
Let me finish. This contradicts your evidence that you gave just now.
Which is
that
Gary had done everything that he can.
Could you let me finish?
Just listen to the question.
Thank you.
Okay.
This contradicts your evidence that you gave just now, which was that you decided to discharge him in August 2022 because that you as the team felt you had done all you could for him. And I suggest this contradicts that because it shows that Mr. Carter considered there was more that could be done.
At the end of the day, if Mr. Carter comes along and says to us, I've done everything that I can, then we have to take him at his word. If he then decides that there's more he feels he can do, it's yes, I don't know, it's very odd. The timeline does not make sense to me there.
Thank you very much.
Thank you. No. Yes. Yes, Miss Milligan.
Brief lines of questioning. I'm conscious of the time. Dr. Lloyd, I ask questions on behalf of Gary Carter. Can I start with the issue of discharge that you've just been discussing with Mr. Straw? If I could have, please, the Rio notes, the 168 document, just while they're loading. You gave evidence that at some time in August, there was a decision to discharge that was subsequently rubber stamped. So the first entry on this page is an entry by Mr. Carter, 4th of August, and I believe this is the one you were referring to earlier, saying it was some point after this entry that, oh, forgive me, you need the page numbers, 270. It'll come up in just one moment, and it's the first entry on the top of that screen. And you say at some point after this entry, that was when the decision was made in MDT to discharge VC, is that right?
That's definitely what I believe, because my recollection is distinct and clear of Gary bringing the case to the meeting for discussion, and the discussion taking place of discharge, and I think versus reporting him to the police. And in fact, I think Gary says that it's something that we need to consider, and I don't think it happened around the 4th of August. I think it happened later.
You say it was in August?
I think it was in August, but I can't tell you exactly when it was.
All right. If we look down the page, just for your reference, we heard that Gary went off unexpectedly on carer's leave from the 25th of August 2022. But there's a reference here on the 31st of August to, at the bottom of the page, to Gary nonetheless taking a telephone call from Celeste. You've just been through this with Mr. Straw. Celeste reporting she'd not seen Valdo face-to-face for many months, but she'd had a telephone conversation with him, attempted to go and see VCs, not at the address. And then the final line, I feel in the circumstances I'll arrange a visit with a colleague to go out and see him to determine his mental state and general well-being. So my question is, even if, and it's an if, there had been a decision to discharge VC that was yet to be rubber-stamped, in your words, this was a material change that warranted consideration by the team, wasn't it?
Say that again. What was the material change? The
VC's mother calling up and in essence expressing concerns, and VC's care coordinator saying, in the circumstances, I need to go out and visit him. That was a material change to whatever may have been discussed earlier in August.
I think earlier in August, as soon as we got the new address.
But forgive me, I don't mean to be rude, but we're tight on time. That's not the question. I'm saying if it is the case that a decision has been made to discharge VC, and it's an if, but let's proceed on that basis, by the 31st of August, there was a material change, and it warranted you and the other members of the EIP team to look again and say, actually, before we rubber stamp this, is this the right decision? That's right, isn't it?
I don't think I was aware of this particular entry from the 31st.
You didn't look at the Rio notes prior to the MDT meeting to discharge?
No, because I thought the discharge decision had been taken, so no. If I believe that he's actually been discharged already, it seems odd to then go back and look at the notes.
So even if it's yet to be rubber stamped, it's your evidence that you don't need to look at the Rio notes?
If all we're doing is a process of administration, yes, this person has been discharged, but Gary hasn't got round to doing the paperwork, then yes, I wouldn't necessarily go back and specifically look at the notes, because as far as I'm concerned, that discharge decision has taken place.
Could I take you to another document, please? NHFT 0018512. And this is an email. You're not copied in it, just to be clear.
Oh, right.
But this is from Miss Parsonage, dated the 8th of September. Hi, all. Looked at Gary's patients. Here's what we've got over the next few weeks. And we'll see below the big redaction. VC, Gary has put this on Rio. I feel in the circumstances I will arrange a visit with a colleague to go out and see VC to determine his mental state and general well-being. Discuss MDT. So the team, the broader team, certainly didn't think he'd been discharged. They're referring to VC as a patient that needed to be discussed at MDT. So he hadn't been discharged at this point, had he?
But as far as I'm concerned, the decision to discharge had been taken. It's just he hadn't been discharged. We had the conversation. But it doesn't look as though the paperwork was done. I honestly don't know, but I can tell you for a fact that I remember that meeting specifically. And it may be that we had the discussion, but then a decision was taken after that not to discharge him. I really don't know, but I know what I remember. And I remember Gary specifically coming into the room and saying, I have done everything that I can, and us talking, the whole team talking about all the options. And if you look at Gary's witness statement, again, in there, he states that he comes into the MDT and he believes it's in August, and he says, I have done everything that I can. And it's at that point where we go through all the options and discharge becomes something very prominent. And it is there in his witness statement, because I read it, because I was questioning, this is odd, the timeline doesn't look right. And when I looked at Gary's statement, I actually saw those words.
All right. One more document, please, just building on this. NHFT 0018292. This is a week later, 16th of September 22. It's another cover email. So there's been an MDT to discuss what Gary had written on VC's Rio records. A week later, Ms Parsonage again emailing around. Here's the cover for next week. If we could just pop down later down that page, please. It may be on the next page, forgive me. There we go. We see one of Gary's patients, VC, discuss Tuesday discharge. So there were discussions, weren't there, in MDT in September about VC, and those culminated in the decision on the 23rd of September 2022 to discharge VC. That didn't take place at an earlier date. You're simply wrong about that.
Discuss Tuesday discharge. Well, we don't have MDTs on a Tuesday.
That's not the question I'm putting to you. I think I've put it. And
Yes, thank you.
All right, that's fine.
Point.
thank you.
Yes, Ms Patry, do you want to raise anything? Sure.
Thank you. Dr. Lloyd, I ask questions on behalf of the University of Nottingham.
Okay.
3 very short topics.
Sure.
A paragraph 160 of your statement, which I can turn up if it's helpful, WITN 035 7001, page 56. You seem to... I'll give you a moment to look at it. Just cast your eye over paragraph 160. You appear to suggest that you considered the incident at the university on the 15th of January, the assault on the flatmate, had not been triggered by psychosis. Do you see that where you've written that?
Yes.
Now, the university's position is that it was never told that, and the question I have for you is, did you at any stage inform the university of that, or instruct anyone else, including Claudia Bertels, to tell the university that?
The reason why I have considered that it wasn't driven by psychosis was because...
Sorry, forgive me. I have 5 minutes.
Yeah, okay.
It's not about why you reached that conclusion. Did you ever inform the university of that conclusion, or instruct anyone else to inform the university of that conclusion?
That I didn't think it was driven
by psychosis.
I would have expected that the individuals that carried out the Mental Health Act assessment, who have written that down, the ward that couldn't find any psychosis, would have had liaison with the university.
Asked a specific question as to whether you did.
No, I didn't, because it wasn't something that I had any first-hand knowledge of. It was just something that I had picked up from the notes.
I'm very grateful for that answer. The second question I want to ask you is about the time of the Mental Health Act assessment that took place around the 19th of January. The relevant AMP report, again I can turn it up but I don't have much time, reports that the advice from the psychiatrist was to tell the university to keep VC stable given that he had not been detained immediately. Would you like to see that?
Sure.
It's NGPF 0003312. And we're looking at the bottom of page 5 and the top of page 6. page 5, going over to 6. Sorry, I can't see the page very clearly. Is that 5? Discussion with LA University Mental Health. LA advisor was ambiguity. Rivaldo residence at Raleigh Park, meaning he may not be allowed to go back on through disciplinary procedures. Dr. Skelton provided some input to LA, advising that a community plan is the least restrictive option. I'm not going to read it all, but the very last part of it, it was emphasised by Dr. Skelton that stability for VC was important to the community plan being successful. So that's what the psychiatrist had advised, and that's what was contained in the AMP report. The question I have for you, Dr. Lloyd, is, do you agree, having given your knowledge of VC at this relevant time, this is January 2022, do you agree that it was important for VC to remain as stable as possible in order for the community plan to be successful?
Yes.
Thank you. And then finally, please, in a number of places in your witness statement, you seem to suggest that the University Mental Health Services didn't inform you of any incidents during the relevant period. I'm going to ask if you could please look at paragraph 283. That's back at WITN 0357 0001 at page 103. So if I can situate you in time here, because I have a very long statement, you're addressing the period December 2021 here, and you can see that if you scroll back up. But in the interest of time, please take it from me that you're talking about period December 2021 here. Mm-hmm. You appear to be saying, right at the bottom of that paragraph, the University Mental Health Advisory Service had not shared any concerns regarding VC with us at this time. Now, can I just ask you this question? The university was wholly unaware that VC had committed an assault on PC Pritchard. It was wholly unaware that he'd been admitted to hospital after that assault. And in fact, we can't see that there was any communication between mental health services and the university at all until January 2022. So what I want to know is, what incident or concern do you see should have been communicated by the Mental Health Advisory Service during that period?
I think I was just suggesting that if there had been an incident or anything untoward, that we perhaps might have heard from the university. It was no more than that.
All right, so it's not a suggestion that we failed to do anything?
Not at all, no.
Given that the NHS held the risk in relation to VC, do you accept that you or your team should have told the university or arranged for the university to be told about all the issues which took place between September 2021 and the 15th of January 2022? So that's the assault, that's the admission, and that's we've heard extensive evidence on it today, that's all the failures that your team had in either engaging VC or treating him during the relevant period. Wasn't that something that you or your team needed to tell the university?
I think, in retrospect, yes, that ought to have happened. We ought to have said at that point, when we found that he'd completely disengaged. I think he was seeing Claudia right up to sort of December. But yes, after that, there was a disengagement, and yes, there should have been better communication with the university.
Were there any barriers to communication between your team and the university?
I don't think so, and I don't know why. You know, I also take responsibility. I don't know why there wasn't that communication. That should have happened.
I'm really very grateful for that answer. Thank you. Yeah. Those are my questions.
Thank you. Yes, just one question. Dr. Lloyd.
Yes.
You said at one stage when you were asked about risk, you said about the tribunal ruling, you said that you didn't think you ever saw the ruling, and you were asked about it, where it says that the risks were serious. And I think you said the only time the risks have been serious was in relation to PC Pritchard. That's right.
At that point, yes, I felt that that was a very serious incident.
There's a difference, isn't there, between the risk of something happening and it actually happening.
Yes.
And what you were being asked about there was the assessment of the risk of something happening, and they were saying that there were serious risks.
Okay,
Do you
yes.
disagree that there were serious risks rather than a serious incident?
No, now that you frame it in that way, I can see that, yes, there are risks that are serious.
It's not how I'm framing it. I just want to know whether you were considering it in that way, about risks of things happening rather than incidents
Yes,
which had happened.
We recognised that there were definite risks with VC.
And just finally, in relation to what you've just gone through, in relation to your recollection that in fact VC was discharged in September, I think you told the inquiry that it would be for the care coordinator to bring a case to the MDT. Is that right?
That's what normally happens, that the care coordinators go through their caseload and they if there's individuals that they feel need to be discussed, and generally speaking, I think Gary Carter always discussed, I think he pretty much discussed all of his cases, to be fair.
The only care coordinator present that we know about on the 22nd of September, when there is this note of the discharge, was Abby Parsonage, who says she was only there for about 15 minutes. So who brought that case to the MDT?
That's what I don't know. That seems...
Well, I'm going to ask whether it was you.
No, absolutely not. Because I thought he'd already been discharged.
I see. Thank you. Right, we'll finish there for today. We'll start again tomorrow morning at 10.
Please stand.